Is everybody awake now? Good morning. How is everyone? Thank you, Nacho Mama. Thank you, Kez Chick. I really appreciate that. It's not really new. I used it before. I used it on like that video I made of all the best trial moments, the long one. Yes. Yeah. I try to be a classy chick. I don't think it's gospel, babe. I think it's more like opera. But I do like when opera and techno come together. I've always liked it. So, yeah, I'm still living in the 90s. That's when I was living my best life. Sure was. I was young, footloose, and fancy free was everything. So, I wanted to come just live just a little bit early so that we could, just catch up and I could say good morning to everyone. Good morning, Nacho Mama. Good morning, Kez Chick. Good morning, Cement Shoes. Good morning, Mrs. O. Good morning, Yvonne. Good morning, good morning, good morning. I don't think I missed anyone. Nope, looks like I got everyone, I think. Yes, yes, yes. Good afternoon to you too, Pickle Lover. How are you? Yes, they did. I liked Enigma as well. I forgot what I was going to say. Oh, I have no idea what's going to happen today. None. I know that Amber Heard's side has around 4 hours left to present their case. And pretty much that's about all I know. I do not think that they rested yesterday. I could be wrong about that. Well, I'll be surprised. I've been wrong before. So who's know? But I don't think that they have rested yesterday. I know there's been a lot of talk about the time left, and I was watching Law and Crime yesterday, like after court had ended, and they were, and I was watching at lunch too, and they were talking a lot about the clock and how much time had they had each side had left, and then they were talking about like, oh, thank you, Kezchick. Hey, New and Honey. Well, I'm I'm just glad you're here, even if you do fall asleep. It's almost 9 o'clock here on the East Coast of these United States. Oh, I like when Johnny wears the lighter blue. That is my one of my favorites. Anyway, stop distracting me, Mr. Depp. But they were asking if the cross exam eats into the time, and evidently it does. So I would not like the job of being the person who kept up with the time. Time is, I just wouldn't, I would not enjoy that at all. And I mean, you see the body language here? I'm sorry, you guys. I'm very distracted by what's going on. Y'all know how I roll. Okay. Um, so I have no idea really exactly how much time each side has left, and I have no idea how they're going to use it, and I have no idea what's happening today. All I know is that Kate Moss is supposed to testify. I don't know about that for sure, 150 million, 11 billion%. No, he really cannot, Nui and honey. It's not his fault. It's really not. I should not blame him. But I also, what I find interesting is the put on between Amber Heard and her team, because to be quite honest, we've all been watching this entire trial, and there's moments like these where we're just sitting around waiting. And what I'm noticing is that I would imagine it comes from her PR team, who has taken notice of how close uh, the Depp team appears to be with their client, Mr. Depp. And it seems to be genuine. Like, I've watched, like you guys have, over the course of this entire trial. And Ben Chew and Johnny Depp seem to have a genuine friendship. I will say that obviously, uh, Ben Chew is employed by Johnny Depp, okay? But I've watched other client attorney relationships, and these guys seem to be like actually friends, friendly with, they enjoy each other's company. And I noticed that when Amber Heard and her team tried to put on that they are close that way, it just rings so disingenuous and hollow, because when somebody comes in to give you a hug, you can tell by the receiver of the hug. Bless it. Hold on. You can tell by the receiver of the hug who the the whether it's genuine or not. And truth be told, Amber stiffens up when Elaine comes in to give a hug. It's not genuine. They don't actually like each other. They're probably fussing and fighting a little bit. It is what it is.
Hi, good morning.
Hi, good morning. What are you doing with your hair, Amber? Come on, lady. Like, you're supposed to have. I feel like the hair deal is intentional, because I don't think I think she wants to portray it as like she doesn't have um a fancy team, so they can barely do hair, let alone come out with bruises, manufacture bruises from her makeup team. Oh, hello, Mr. Depp. How's it going, sir? Good to see you. Good to see you.
hear it in my room.
See, he's just such a much more genuine person, you know?
My understanding that the defense is resting, is that correct?
Oh,
I'm not sure
fucking
what the jury has
finally.
to take him back in, so when after we finish our motions and they come out, I'll let you say. Yeah, okay, let's just do it that way.
Yeah, let's
All
just
right,
do it that
so
way.
based on them resting, you have a motion? And I did receive your memo ahead of time, so I have reviewed that. Okay.
I don't know that okay, I believe the 4 hours left, but 16 I think is I don't
think
know
it's just
that
an
that's
oral.
Hey Sarah, I don't think that's accurate, babe. I think that it's less than 16. I'm thinking that it's
Good morning,
closer to
Your Honor. May
8,
it please the court
maybe
and
even
to the
7.
plaintiff, Johnny Depp. Mr. Depp hereby moves to strike defendant Amber Heard's counterclaims because Ms. Heard has not proven by clear and convincing evidence that Mr. Waldman made the 3 allegedly defamatory statements with actual malice.
Right, but clear and convincing is not my motion to strike standard.
Understood, Your Honor.
Okay.
And we have cited the
Okay.
standard in our brief.
Thank you.
Moreover, Your Honor, the court should also strike defendant's claim for immunity and attorney's fees based on Virginia's anti-SLAPP statute, as she is not entitled to immunity under the statute. Because we know that the court has carefully reviewed our motion papers, I will just hit some of the salient points.
Thank you, sir.
Thank you, Your Honor. I would mention, however, Your Honor, that because this is not included in our brief, that there is no record evidence whatsoever that Mr. Depp even saw any of the 3 statements that Mr. Waldman made prior to being served with the counterclaims in this action, which we believe is relevant to many of the legal standards. And as Your Honor is aware, Ms. Heard had signaled for the past week that she was planning to call Mr. Depp in her case in chief. And it was our anticipation that she would try to fill what we believe is a gaping hole with respect to the elements of her proof. Again, there's no record evidence whatsoever that Mr. Depp ever saw any of the 3 statements about which Ms. Heard is purportedly suing him for $100 million. As Your Honor is aware, the elements of defamation are as follows. 1, publication of 2, an actionable statement with 3, the requisite intent. See Thorpe versus Sanders, 285 Virginia 476 at 2013. The requisite intent for defamation against a public figure is actual malice. That is, the statement must be made with knowledge that it was false or with reckless disregard of whether it was false or not. See Sanders v. Harris, 213 Virginia 369 at 372, a 1972 case. See also Jackson v. Hartig, 274 Virginia at 2019. Reckless disregard, as Your Honor is aware, quote, is not measured by whether a reasonably prudent person would have published or would have investigated before publishing, ellipsis. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication, unquote. St. Amant versus Thompson, 390 U.S. Supreme Court, 727 at 731. Your Honor, the evidence shows that Ms. Heard cannot prevail on her claim because she cannot and did not establish that Mr. Waldman made the statements with actual malice. Mr. Waldman testified that he conducted extensive investigation and reasonably believed that the 3 statements he made were true. Ms. Heard presented nothing to contradict that undisputed fact. Ms. Heard has no evidence of direct liability because obviously, Your Honor, we need to talk about direct and vicarious liability, but it bears noting that she has no evidence of direct liability and cannot prove actual malice by Mr. Waldman when making
Hey,
the three
Nosy Nana,
statements
Max
at issue.
2002,
It
Amelia
is
Sparkles,
undisputed
Welsh
that
Pam, good
Mr.
morning, good
Depp did
morning.
not make any of the three statements at issue in Ms. Heard's counterclaim. Moreover, in order for Mr. Depp to be liable for the conduct of one of his attorneys, there must be some showing that he directed, participated, or otherwise authorized Mr. Waldman to make the statements at issue. There is no such evidence.
Okay, Sarah, so what they're doing right now, what Ben Chu is doing is making a motion for the court to dismiss Amber Heard's counterclaim for, as her outfit the other day suggested, her Dr. Evil attire, $100 million. The reason that they're doing, and what he's doing right now is making arguments to that effect, because in order for her to be able to prove her counterclaim, she must prove that Mr. Waldman's statements were done with malicious intent. And under the definition of law, for the law, malicious intent is not like we would think of something that's malicious, like doing it because they're mean. This, under the law, malicious means knowing it's not true. Okay, he issued statements that he knew were false. Okay, and the way that okay, so there's that element. Then the second element of that would be that Johnny Depp is responsible in some way for these statements made by Mr. Waldman with malicious intent. because Johnny Depp, because Mr. Waldman was Johnny Depp's attorney. Amber is asserting that therefore he knew what Mr. Waldman was doing, and he approved of the statements Mr. Waldman was issuing. In fact, she's gone a step further to say that, or to allege that those statements made by Mr. Waldman were done at Johnny Depp's behest. Okay. So when they had Mr. Waldman on the stand, he could only testify to so much because of attorney-client privilege. And because they are resting, they're evidently not going to call Johnny Depp. Johnny Depp is, I don't think, going to be I don't think he's going to testify as a rebuttal witness in his, but I don't know that. So what Ben Chu is saying is, under the law, under the rules in Virginia for defamation, Amber Heard has failed to meet her burden of proof, because what they needed to do, her team needed to connect Johnny Depp to the statements made by Adam Waldman. They needed to show proof that Johnny Depp knew about the statements he was making and approved those statements. Otherwise, what she would have to do would be to sue Adam Waldman, not Johnny Depp. The only way that she can get the $100 million out of Johnny Depp is to connect him to Adam Waldman, and they failed to do that, which is what that's Ben Chu's argument. I personally agree. But he cannot be held liable for what Ben Chu does and that's what Ben Chu is arguing right now. There is no evidence connecting Johnny Depp to Adam Waldman's statements, which is which is the essence of her
and this is reflected in
counterclaim.
the transcript that Mr. Waldman met Mr. Depp first in October of 2016, long after the fact. Nor is there any evidence in the record that Mr. Waldman subjectively entertained any serious doubts about the falsity of the counterclaim statements. Quite the opposite. The evidence shows, and it's unrebutted, that Mr. Waldman had very reasonable grounds to believe, and he did believe, and will to his dying day, that Ms. Heard's claim of abuse were patently false. Mr. Waldman testified at length about 29 witnesses he believed disproved Ms. Heard's false claims of abuse. See the transcript at page.
No, babe, you did not
6008
interrupt, and you're
through
more than welcome. I hope
6012,
I
and won't
explained
run
that
through all of
correctly.
them.
I'm like
But his
93% sure I got it right.
Police officers, Officer Science and Haddon, were called to the penthouse on May 21, 2016, and saw no signs of injury on Ms. Heard's face, as well as, quote, Ms. Heard's own witnesses who have testified in various forms at various times that there were no injuries to her face whatsoever between May 21st and May 27th, 2016, when she walked in to court with her publicist, her lawyer, her former best friend who no longer speaks with her, for a no-notice ex parte TRO. Some of the witnesses whom Mr. Waldman has cited, they include Laura Devanere, Melanie Iglesias, who, as Your Honor recalls, was Ms. Heard's makeup artist, who decided to end any professional or personal association with Ms. Heard. Samantha McMillan, Hilda Vargas, Isaac Baruch, Trinity Esparza, Cornelius Harrell, Alejandro Romero, and Brandon Patterson, just to name a few. No reasonable jury could find that Mr. Waldman acted with actual malice in making the allegedly defamatory statements. He was not present for the alleged incidents. He has no personal knowledge of any of the alleged incidents. What Mr. Waldman knows is a product of the legal work he did, the sleuthing he did on behalf of Mr. Depp. Ms. Heard cannot possibly show that Mr. Waldman acted with actual malice, and her defamation claim must fail. 2, Mr. Waldman is an independent contractor, not an employee. It is axiomatic, Your Honor, that a person who hires an independent contractor is not liable for the independent contractor's actions. See Sanchez versus Medicorp Health System, 270 Virginia, 299 at 344. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way to bring about that result. See Atkinson versus Sachno, 261 Virginia, 378.
I agree, New Ann, honey. He's breaking it down, and I love it.
An outside lawyer retained by a client in connection with litigation is an independent contractor. See King versus Dalton, 895 F. Sup. 831, Eastern District of Virginia, 1995, where Judge Ellis, a legendary jurist known by all Virginia practitioners, held that, quote, a law firm attorney working with a client is nonetheless an independent contractor and is not an employee of the client corporation. In that case, the employer was a corporation, but the same logic applies when it's an individual like Mr. Depp. That was Mr. Waldman's role. Indeed, clients hire lawyers to obtain specific results, or to try to obtain specific results, but they do not control the means by which the results are accomplished. Lawyers, as Your Honor has reminded us, are subject to professional obligations to exercise independent professional judgment. We are not at the whim of our clients as much as we want to serve them. See Virginia State Bar Professional Guidelines, Rule 1:2 and 2.1. And just to quote 2.1, in representing a client, a lawyer shall exercise independent professional judgment, unquote. Mr. Waldman is, as a matter of law, an independent contractor, and Mr. Depp cannot be held responsible for any alleged tort by his attorney, particularly for statements about which he was unaware until he was sued for them. Mr. Waldman testified, and it's unrebutted, that he has his own law firm. He's not an employee of Mr. Depp. Mr. Depp or none of his loan out companies have issued him a W-2. And Mr. Waldman provides legal services to clients other than and in addition to Mr. Depp. And that's found at the transcript, page 6020 through 21. All of that is unrebutted by Ms. Hurd. Mr. Waldman's statements, the third reason for which we respectfully submit the
Good morning,
counterclaims for
Schmida.
constriction
Good
is that
morning,
Mr.
Rhoda
Waldman's
Gal.
statements
Good to
were
see you
protected
guys. You know,
opinions.
I love
I
it.
won't run
You
through
guys,
all
when
of
you're
that,
here,
but very
we just
briefly,
love it. We're going to get this through
taken
this
in their
together,
proper
y'all.
context, the counterclaim statements are non-actionable expressions of opinion entitled to protection under the First Amendment. See Gertz versus Robert Welchink, 418 U.S. 323 at 339. That's a 1974 case from the United States Supreme Court. See also Shacker v. Bufault, a Virginia Supreme Court case found at 290 Virginia 83, a 2015 case, noting that where, quote, all sides of the issue, as well as the rationale for the speaker's view were exposed, the assertion of
I'm glad you
deceit
didn't choke.
reasonably could be understood only as the speaker's personal conclusion, unquote, and finding in an accusation
Hey,
of
Chick
deceit
Tracy.
to be opinion. In context, Your Honor, any reporter or any reasonable reader would understand and expect a lawyer associated
I
with
have
Mr.
to
Depp,
say,
as Mr. Waldman does,
just
to
while we're
challenge Ms.
listening
Heard's
to this,
version of
Johnny
the
Depp looks
inherently
much more relaxed
controversial
today
events
than
of the
I've seen him
parties'
in a while.
marriage.
He's looking more
Just as
relaxed
Ms.
each
Heard's
day.
lawyers were quoted challenging Mr. Depp, and Your Honor will remember the context of these quotes that were in a British tabloid where Mr. Waldman's statements were buried well into article in which both points of view were clearly expressed. And Mr. Waldman was clearly identified not as an independent expert on the U.S. Constitution, but as one of Mr. Depp's attorneys. C. Chavez, 230 Virginia 112 at page 119, quote, the most unsophisticated
Hey, mi amor,
recipient
Michelle.
of such a claim,
Good to see
i.e.,
you.
any reader of the British tabloid,
Mr. Chu, did Camille
made by a
Vasquez not
competitor
help you
against
to pronounce
another,
these
could only
words? It's
regard
not
it as a relative
Chavez.
statement
It's
of opinion
Chavez.
grounded upon the speaker's obvious bias, unquote.
He mu-
Mr. Waldman has never did anything to hide his support.
I mean, it's not in the bag quite yet, but
Mr.
I'm
Depp.
sure he's got to be feeling more
Finally, Your
confident
Honor, and
today
for the
than he
rest,
was
ultimately,
at any
Mr.
time,
Waldman's statements reflect the existence of two competing
especially
narratives
after yesterday.
and
That
are
was a
merely
whole
his
mess.
subjective view
I mean, I don't want to say I've never seen anything like
about
it. I just
events
can't
that he
think of a
never
time when
claimed
I've seen
to have witnessed.
something like
No
that.
doubt
So,
about that. Turning to the
that's
second
a lot.
part of the argument, which will be more abridged, Ms. Heard is not entitled to anti-SLAPP immunity. As a threshold matter, Virginia Code Section 8.01-223.2, which is, as Your Honor well knows, is the Virginia anti-SLAPP statute amended most recently in 2019, provides in relevant part, quote, the immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false. Here, in addition to Mr. Depp's testimony, several witnesses have testified that A, they never witnessed Mr. Depp abuse Ms. Heard, and B, that they observed Ms. Heard without any injuries, marks, bruising, swelling, etc., during periods when Ms. Heard claimed to have injuries, marks, bruises, etc.
Also,
Such
let me
witnesses
just
include, but are not limited to,
say
Bruce,
something real quick
Haynes,
too, with
Nurse
respect
Pipper,
to
Nurse
Adam
Officer
Waldman, Mr.
Science
Waldman, his
Hadden, Officer
Johnny
William
Depp's
Gatlin,
former attorney.
former U.S. Marine Starling,
the
Texas.
biggest
Ms. Heard's
element in the
request for anti-SLAPP
oh, Ben Chu, I want to hear you, but you're distracting. I'm
strengthened,
sorry.
even if
One of the biggest, most profound elements in the argument to dismiss is this acted with malice, right? Not reckless, with malice. Okay, So, which means lies. And the thing is that one of the things that Waldman did testify to was the extensive investigation that he conducted. And that's going to be crucial if the judge agrees with Mr. Chu's assertion that Mr. Waldman said what he said, gave the statements he gave because he, in good faith and as a result of an extensive investigation, believed that Amber Heard's statements of domestic violence claims against Johnny Depp were false, then she will have to dismiss the case. Okay, let's hear what Rottenborn is saying.
He's now directing his arguments to something other than what's at issue here, and I would object because I think making an argument not to you but to the cameras, it's disrespectful to the court and to everyone's time, and it also threatens to undermine the integrity of this process and the jury being influenced by outside factors.
It's his argument.
Thank you.
Thank you.
Thank you, Your Honor. As I was trying to say, what Mr. Depp is suing about are the three statements. And it's very clear, despite the pious opening statement that about the First Amendment, that with the testimony of Terrence Doherty and the emails that were admitted as exhibits, that the ACLU and Ms. Heard were conspiring to make it very clear that those three statements were related to Mr. Depp, because otherwise nobody had any interest in the article. And it's crystal clear from that. They wanted to time this thing with the release of Aquaman, which was her first film of any significance in terms of popularity, and to do that. That's very clear. So the charade that this had something to do with public policy is risible, and that is not why the anti-SLAPP protections were enacted. They were enacted to protect the rest of the article, not what Mr. Depp is suing about. As generally analyzed by the courts, a matter of public concern is one which relates to, quote, a matter of political, social, or other concern to the community, unquote, as opposed to a matter of only, quote, personal interest, unquote. That's Connick versus Myers, 461 U.S. 138 at page 146. Instead, the defamatory implication at issue in each of the three statements at bar relate to the personal grievances between Mr. Depp and Ms. Heard, which does not rise to the level of a matter of public concern with broader implications for society beyond the two litigants in this action any more than Mr. Waldman's statements. I mean, adding the gloss of public policy might immunize the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. We're talking about the three statements that they very intentionally and very cleverly put in to make it clear the implication that it was about Mr. Depp. They had lawyers from the ACLU working around the clock with Eric George.
Good morning, Sugar Beet.
To be as clever about this as possible. And Your Honor remembers the testimony of Mr. Doherty about the consternation at the ACLU when they realized that USA Today and everybody else who read the article knew darn well that this was about Mr. Depp. This cannot be protected by the anti-SLAPP statute. It is a cynical runaround. And I think now that we have the undisputed evidence from the ACLU in the form of the testimony of Terrence Doherty, who's not only their corporate representative, he was their general counsel. He is a brainiac lawyer. They knew exactly what they were doing.
Tell it, Ben Chu. Tell it.
Testimony of a woman at the ACLU who said she had nightmares about Ms. Heard, and he expressed no concern about that. Now, that was either because they knew about, that was either a reference to this game they were playing with the op-ed, or the conspiracy they had to cover up her failure to make the donations. The donations became pledges, but we have evidence that she refused to sign the pledge card. So she's caught either way.
Holy
Simply
guacamole.
stated, Your Honor, Mr. Depp is not suing Ms. Heard for making statements about society in general. I think that's very clear from the record evidence. Mr. Depp is suing her for publicly naming him as an abuser by implication and forever tarnishing his good name, an act that, coming from an ex-spouse, is fundamentally personal in nature. For that reason as well, Your Honor, Virginia's anti-SLAPP statute is not applicable. And based on the foregoing, Your Honor, Mr. Depp respectfully submits that the court should grant plaintiff's motion to strike the counterclaims and also strike her claim that she is immune under the anti-SLAPP statute. Thank you very much, Your Honor.
Thank you, sir. Yes, sir.
All right, Mr. Rottenborn, let's hear what you got
Thank you,
to
Your Honor.
say.
As Your Honor knows, the trial court is required to accept as true all the evidence favorable to Amber at this point, as well as any reasonable inference a jury might draw therefrom, which would sustain the counterclaim. That's the correct standard here. I'll address the actual malice argument first, the agency argument. Your Honor, there's plenty of evidence in the record from which the jury could determine that Mr. Waldman was Mr. Depp's agent. He made those statements. The statements referred to him as Mr. Depp's attorney. As Your Honor ruled on Friday with respect to the jury instruction conference, an attorney is an agent of his client. Mr. Waldman testified that he's been Mr. Depp's attorney since 2016. He freely admitted speaking to the press on Mr. Depp's behalf, and he refused to answer question after question about that agency, so we can't use that as a sword now. Mr. Chu puts a lot of emphasis on the fact that Mr. Depp allegedly didn't see the comments that were made that are the subject of the counterclaim. But as Your Honor well knows, whether he saw them or not is not the standard for agency. There's also evidence that Mr. Depp met with
Amelia.
with Mr. Waldman prior to the defamatory statements.
Thank you, mi
being
amor,
made and
Michelle.
released. I believe that was in February of 2020, just 2 months prior. Mr. Waldman also concocted a story that Amber was being investigated for perjury by filing a perjury complaint against her with the LAPD. He disregarded any evidence that he didn't believe would fit in his narrative, that would fit in this story that he was speaking about on behalf of Mr. Depp. And after Mr. Depp lost the UK proceeding, after Mr. Depp was ruled to be a wife beater by the court in the UK proceeding, the court there found him to be a wife beater. Mr. Waldman then got an overseas tabloid to run a story claiming that Amber was being investigated for perjury, which simply wasn't true. He walked into the LAPD, filed a complaint for perjury against Ms. Heard, found a media outlet that doesn't follow the two-source rule, and then he had let the world believe that the LAPD was investigating Ms. Heard for perjury. That's a shameful and a sickening example, Your Honor, of the lengths that Mr. Depp, through his agent, Mr. Waldman, would go to smear and to defame Amber Heard. And that continued in the 3 statements in the counterclaim. Your Honor has heard evidence. I won't go through all the evidence, but Your Honor has heard evidence from Ron Schnell, who's traced the negative hashtags toward Amber Heard online associated with those defamatory statements and noted the staggeringly high number of them that were associated with Mr. Waldman. Under the principles of the agent-principal relationship in Virginia, Your Honor, when Mr. Waldman made those statements, he was standing in the shoes of Mr. Depp. They are one and the same for the purposes of those statements. As Your Honor discussed at length on Friday, Mr. Waldman made these statements with actual malice. There's plenty of evidence from which the jury could infer that, and his own, both from the actual malice from Mr. Depp and Mr. Waldman's own reckless disregard of facts that didn't support Mr. Depp, and his attempt to manufacture false evidence that did. As Your Honor found in the hearing, I believe it was on March 24th, after Your Honor denied Mr. Depp's motion for summary judgment, Your Honor said, as to malice, a fact finder could reasonably conclude that Mr. Waldman made the statements with malice because Mr. Waldman has no personal knowledge of the party's marriage and still made the statements at issue. Nothing in this case has changed that. If anything, the evidence has only made it more clear that that is an inference that the jury can and we believe will find. So, Your Honor, there's no basis to grant a motion to strike on this agency argument, on the actual malice argument. The evidence shows that not only was Mr. Waldman Mr. Depp's agent, but that the two of them conspired to falsely accuse Amber of creating a hoax and falsify evidence that they believed supported their theory and what they wanted to achieve. As Your Honor well knows too, I won't.
They
go through all
have
the
to
law,
bring
but
it in,
both
Shmita,
agency and
because
analysis
regardless
can be
of what
inferred
the
through
judge
circumstantial evidence.
said about
There's
that,
plenty of
it does
evidence in the
go
record
to
from
their
which the jury
argument
could infer those. Moving on, Your
that
Honor,
Johnny
to
Depp
independent
is
contractor. The court's already
responsible and
rejected the
liable
Sergeant
for
rule
what
that
his
attorney,
attorney did.
client have a principal agent relationship, and as Your Honor said on Friday, there's no evidence in this case of anything otherwise.
And that
As to
regardless
the
of her
argument
opinion,
that the counterclaim statements are statements of opinion, the court has already found twice that they are not statements of opinion, both on January 4th, 2021, in its
Hold on.
opinion letter denying Mr. Depp's demur as to the counterclaim statements, and at the motion for
whether or
summary
not the
judgment
judge
hearing
feels
in
that
March of this year.
Mr. Depp
As to the
received a fair
anti-SLAPP
trial or
argument, the
not,
court again
the
has already
trial
ruled that the March
results are the trial
24th,
results, and they have to bring it in, because they have to remind everybody
matter of law regarding
that
matters of public opinion.
Amber
The
is
court
not
has already ruled that. Therefore, the only
lying.
remaining issue for anti-SLAPP is whether the intent element of immunity is met. As we discussed on Friday, the intent element of immunity is substantially the same as the actual malice standard, which the evidence in this case easily allows a jury to find in favor of Ms. Heard on that. I won't go through the litany of evidence that supports that Mr. Depp is an abuser here, but I'll touch on a few things that relate to Mr. Chu's argument. One, Mr. Chu was totally misrepresenting Mr. Doherty's testimony. There's not a single piece of evidence, Your Honor, in this case suggesting that Ms. Heard and the ACLU were somehow conspiring to achieve a defamatory implication to Mr. Depp. That's simply not what
Bruh,
Mr. Doherty said.
there
Mr.
were
Chu is
emails.
free to argue that to the jury, but that's not what his testimony reflects. Your Honor,
It
there's also
absolutely reflects that. Were you listening to the same
plenty of
testimony
evidence
as the
that's
rest of the
been,
world?
adduced both in
Sorry.
Mr. Depp's
Sorry.
claim and in
I'm
Ms.
sorry, I
Heard's
had an
counterclaim
outburst.
that show that absolutely that the counterclaim statements are 100% false. There was no hoax perpetrated. Mr. Depp is an abuser who abused Ms. Heard. She did not conspire with her friends to create a hoax. She did not create a hoax herself. And just very briefly, some of the evidence that's come up since the last motion to strike, Your Honor, that Mr. Chu conveniently disregards in his brief are the testimony of Rocky Pennington, testimony of Josh Drew, testimony of Elizabeth Mars, all of whom completely corroborate Ms. Heard's account of the events of May 21st, 2016. The testimony of Melanie Iglesias, who testified that she covered Ms. Heard's bruises with makeup right after the December 15th incident, that provided ample testimony to support that Ms. Heard often would cover her bruises that were caused by the plaintiff, in this case, by Mr. Depp, with makeup. He ignores the evidence of Christy Sexton. He ignores the evidence of Io Tillett Wright. He ignores the evidence of Whitney Enriquez. All of these witnesses and others have testified extensively about Mr. Depp's abusive behavior toward Ms. Heard. Physical abuse, emotional abuse, psychological abuse, verbal abuse, Your Honor. Mr. Depp's own writings, recordings, pictures, and videos confirm that. The list goes on. There's abundant evidence in the record, Your Honor, from which the jury could, and again, we believe will find that Ms. Heard is not liable for defamation to Mr. Depp, and therefore, by definition, she has not acted with actual malice, and based on the court's rulings on March 24th, 2021, she would be entitled to anti-SLAPP immunity, which would permit her to ask the court to award attorney's fees against Mr. Depp. So with that, Your Honor, I'm happy to answer any questions the court has.
That's
but
fine.
that
Thank you,
covers
sir.
it. Thank you.
Yes, sir.
Your Honor, I will be brief in deference to the court's time and the jury's time. What Mr. Rottenborn said about Mr. Waldman's allegedly going to the LAPD about perjury is a complete non sequitur. If they thought that that were somehow improper conduct, they could have included it in their counterclaims. They included everything else but the kitchen sink, and most of it was thrown out. There was nothing in there about Mr. Waldman going to the LAPD. So that is a very clear non sequitur, red herring distraction. Number two, when Your Honor ruled on summary judgment on the issue of the counterclaims, Your Honor was dealing with a different standard and a different evidentiary record. At that time, Mr. Waldman had not testified, which is material. Mr. Waldman has now testified for purposes of trial.
Hi,
Have his trial
Navigator.
testimony. It's very clear that he did not act with actual malice. They didn't even argue that. So that's pretty clear. And again, this is consistent. The third point is that it's all about games. They didn't sue Mr. Waldman on the 3 statements. They didn't try to fill the hole. They've been telling us for a week that they're going to call Mr. Depp to try to fill the hole in their counterclaims. They didn't do that. And it's very consistent with the game playing. Let's go into court after the police have found no problem and after witness who have no relationship with each other, so there are no visible marks. Let's not give Mr. Depp's lawyer the required 24-hour notice before the TRO. Let's march into court with our publicist, with our lawyer, with our best friend who no longer talks to her. Let's get a TRO.
Boom.
And when the Me Too folks say, why are you taking $7 million from an abuser? They said, I didn't take money from the abuser. I gave it all to charity. Well, they didn't. I don't think anybody should feel bad about them stiffing the ACLU, given what the ACLU did in this case, which is a monstrosity. But she did stiff the sick and dying children. It is gamesmanship. And that's what she's doing here today. But the law is the law, and they have not fulfilled their burden with respect to the counterclaims. There is virtually no nexus between Mr. Depp and Mr. Waldman as to these statements at issue, except for the fact that he is an attorney, and that is not sufficient. In a case where they have not even established that Mr. Depp was aware of these statements, and they knew that they couldn't do it, and they didn't even try. And it's more of the gamesmanship when Ms. Heard plays word games with Mr. Depp about, oh, I didn't punch you, Johnny, I just hit you. Imagine if the shoe were on the other foot and Mr. Depp, a man, was saying to a woman, oh, woman up, I only hit you, I didn't punch you.
Exactly.
And it was chilling when she warned him on the tape, you go tell a judge, you go tell a jury that you, a man, were abused. See if they're going to believe that. It is an abuse of the system, and she's done it throughout. Finally, Your Honor, and Mr. Rottenborn makes an excellent point with which I agree, which was that with respect to each of the 3 statements, Mr. Waldman was clearly identified, even by the tabloid that printed these, well within articles that had both sides represented, that he was Mr. Waldman's attorney. Even the reader of a tabloid understands
he
that
meant
when
Mr.
you're getting
Depp.
statements from attorneys, it's going to be forwarding their client's point of view. Mr. Waldman is not the only attorney who has spoken out. Robbie Kaplan, who was Ms. Heard's second attorney. So Ms. Heard started out with Eric George. He made comments to the press.
Objection, Your Honor. Again, this is so much further beyond what Your Honor is addressing.
I'm finishing up, Your Honor.
Okay.
I'm finishing up. My point, Your Honor, and it's on point, is that Mr. George made statements supporting Ms. Heard's position. Ms. Kaplan made very clear statements supporting her client's position on the merits, and so did Mr. Waldman. But everybody knows when reading those that those are statements bipartisan. So for the reasons that we've stated and the reasons set forth in the brief, we respectfully submit that the court should grant the motion to strike, or in light of the fact that Mr. Depp may reappear, at the very least, take these motions under advisement until the close of all evidence. Thank you, Your Honor.
All right. Thank you, sir. All right. In this matter, I've reviewed all the defendant's evidence as to her counterclaim, and I've considered the arguments of her counsel and plaintiff's counsel. First, to address a few issues that I believe are outside the motion to strike, and that's as to the slap defense. The slap defense is just that, it's a defense, so it's really not considered in a motion to strike. Having said that, we went down that legal road on Friday as far as the slap defense goes, as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So we will deal with that with jury instructions, and we have. As to independent contractor, Again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016. Before the initiation of litigation, there is evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation, as outlined in all the cases presenting an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to weigh the motion to strike. As far as the opinions argument, again, I think that is outside the motion to strike. The opinions argument, the court has already ruled on this matter as to the three statements that are issued in the counterclaim, ruled that they were not opinion at the demur and at summary judgment. So that argument will not be part of the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances. When there is no direct evidence, circumstances may, and usually are, relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship, is enacted in part to service the principal can be held liable for the tort. Here, the alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory, with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to serve as plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether the statements are false, and both parties disagree and have presented conflicting evidence as such. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear.
Oh,
that
she's
actual
going to leave
malice
it
is
to
a
the
question for
jury.
fact finder. So therefore, the plaintiff's motion to strike is denied. Okay? Thank you. Is there any other preliminary matters before the jury?
I want to say, okay,
Okay.
I actually, while I agree with Ben Chu that bringing a motion to strike is the right move to make, I actually kind of admire the judge for the ruling that she just made. And I think the reason that I admire the judge is because had she agreed with the plaintiff in this under these circumstances, it would be very easy for Amber Heard to do exactly this. Let me scroll up to this comment right here. Sorry, Shmita, I got to put you on the spot right here. Hold on. Right here. If the judge had ruled in Johnny Depp's favor, it would be very easy for the public and Amber Heard to say she's biased. The judge has already acknowledged that he didn't get a fair trial, yada, 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 right? This removes that from the equation. Because I think what is really at stake here, I'm okay with them taking it to the jury as well. I think what's really at stake here is bigger than $50 million or $100 million. It's the system in place. And who who is the victim and who is the perpetrator, and acknowledging that men absolutely can be the victim. And I think that she did the right thing here. And I profoundly disagree with Mr. Rottenborn that the plaintiff has failed to connect the ACLU in a conspiratorial manner to cleverly word the op-ed in such a manner that it is evident that the op-ed refers to Johnny Depp, obviously not by name, because they can't do that or couldn't do that because Amber had signed an NDA. So, and both of them did with respect to the divorce. And so I think that the jury is very, very likely to see things the way that the way that I see them, the way that most people see them, is that they they were working together. The ACLU and Amber Heard and her team were working together on that op-ed article each and every step of the way. The only thing, the only part of that op-ed that neither the ACLU nor Amber Heard were part of were the titles. That's it. Period. If you watch him in Public Enemies, you'll have that very look. I don't know why Whitney looks so. Frankly, I think Whitney looks angry because she doesn't want to be there. I feel like she's there because out of like family loyalty and pressure, honestly. Like, somebody's got to be there for your sister. I think the judge made a really good ruling. Now I'm curious, and I also like the way that the judge decided, okay, let's get these motions and arguments out of the way, right? Then bring the jury in, because jurors are not stupid, okay? I think that they after Rottenborn filed his first motion to strike, excuse me, pardon me. I think the jury was curious if the plaintiff would do that too, right? And so I feel like if they would have brought the jury in, let the defense rest, and then sent them out again, they would be wondering. This is a much better way of doing things. It doesn't give the jury anything to think about. You know what I mean? This is better, although they are sitting waiting, and they have been waiting probably since somewhere around the 8:30 mark, or whatever time they're told to be there. I think that they get told to be there at 8. I don't know. I can't remember. But, at the end of the day, so yesterday was an epic fail, in my opinion, on the part of Amber Heard's team. And it wasn't an epic fail because I didn't believe anything that the psychiatrist was testifying to. That's not why it was an epic fail. I believe that it was an epic fail because, as knowledgeable and experienced as the psychiatrist is, he is clearly not I don't want to say experience. He doesn't do well at trials. He is not good at testifying, which is a necessary element if you're going to call a psychiatrist to the stand. They must be able to testify, engage the jury, et cetera, et cetera. And unfortunately, what the jury is going to remember is the argumentative nature of the cross-examination because it was so beyond the pale. It was so outrageous. It was so, I don't want to say egregious. That might be like one toe over the line, but it was a farce, the argumentative nature, because he wasn't arguing. In my opinion, it came across as not arguing his point, but more arguing in an attempt to prove how knowledgeable he is on a particular subject, and that was problematic. Oh, and by the way, they heard his voir dire too. That's not going to play well for the jury. Juries are human beings. And when you've been sitting for weeks at this point, granted, they did have a week off, okay? But they've been sitting for weeks at this point, listening to hours, 8 hours of testimony each day with 2 15-minute breaks and 1 hour for lunch, okay? Which a total of time that they get a break per day is an hour and a half, period. Okay. So at the end of the day, it's a ton of testimony. And the testimony is from both sides conflicting. Johnny Depp has his side presenting that Amber is, in fact, the abuser, physical abuser, and that Amber has her side testifying that she is the victim of the physical abuse as well as other types of abuse. And everything is it's a lot of information and it's getting lost. And anything that psychiatrist could have potentially contributed to Amber Heard's case was lost in the spectacle that he made on the stand. And that's the truth. So it was a big, huge waste of time on Amber Heard's part. Not her specifically. Obviously, she doesn't have control over that kind of stuff, but her side's part. And it's annoying. They're wasting time. And I don't care about this money. I mean, I'm sure it's, Johnny Depp, if he was awarded $100 million, he would care, but I think the issue is bigger than the money. I think it's problematic that Amber Heard made not one but 2 pledges, and she has failed to honor not one but 2 pledges. Yet she has testified under oath that she fulfilled the pledge, that she moved beyond the pledge portion and into the donation portion, and she has failed to do that. And she testified under oath that she did, which is perjury, and then tried to get up on that stand and play word games, which frankly might have worked with Johnny Depp, but it was not going to work with Camille Vasquez. Period. So she has stiffed the ACLU, to put it the way that Mr. Chu put it, which I agree with. She did. And I kind of agree with him on the point that they sort of deserve it, right? But at the end of the day, your word is your word, which is exactly what a freaking pledge is. It's a promise. And if you welch on your promises, it speaks to your character. Okay, whether you think they deserve it now, at looking back, Amber, whether you think they deserve it or not, doesn't matter. You said you would do it. You made a commitment. You don't honor commitments. That speaks to your character. And what did the sick and dying children do to you, Amber? You got beef with them? Why didn't you honor that pledge? Because you're not a good, you are not, I'm not going to say you're not a good person. You are not the type of person that honors their commitments. Exactly, Michelle, 100%. And if we're going to go into if we, I mean, while we're just sitting around here waiting for them to do whatever they're doing up there, we could go even further down the honoring commitments road. All right. Um, a marriage where you take vows. What are vows but a pledge, a promise? You didn't honor those either. You had men to your apartment that, let's be honest, Amber, I don't slut shame. I don't care what people do behind closed doors. As long as it isn't hurting anybody else and it's legal, I don't care. It's not my business. It's not my church, so it's not my problem. All right, do what you want with yours. All right? But don't get up on some janky ass high horse as the moral, as if you have some moral high ground when you're sneaking Franco it's not even your penthouse. It's not something that you and Johnny Depp purchased together. It was his. So you bring James Franco up there and you're canoodling in the elevator. I have tons of male friends and have since forever. Okay, high school. And let me say this, when I would go to my guy friends and because some guy that I liked was mean to me, they didn't that's not how they showed affection. They put their arm around me and patted me on my head and said, "It's going to be all right. Do you want me to beat him up?" That's it. We didn't cuddle, we didn't snuggle. We didn't have a cuddle party in the elevator. It didn't happen. And that body language speaks for itself, period. The end. So she isn't a person who honors her commitments on any level. So when everybody is talking about character, at the end of the day, it took real strength for Johnny Depp to get up there on that stand and admit the things that he admitted, including the text messages and the emails that he wrote to various people, including Amber Heard. To get up there and get on the stand in front of God and everybody and say, I have substance abuse issues. I struggle with alcohol. It's something that I have worked at time and time again. I've had periods of sobriety where I've been successful at maintaining sobriety, and then I have had periods of time where I fell off the wagon. And on top of it, acknowledging that the opiate abuse started out very innocuous. He suffered a back injury, he was prescribed pain medication, and people who've never experienced that don't understand what a slippery slope opiates can become for certain people. Some people, it's whatever, it doesn't really, they can have chronic pain and they can take their prescribed pain medication and they take it correctly, and that no matter what is going on in their life emotionally, they don't use their pain medication to numb the physical pain and then emotional pain. There are people that are able to do that, but some people are not. And again, this is another excellent point. Okay. You have her contacting him after she's issued the restraining order. Okay. Then you have the audio where I just want to hug you. I just want to hug you. Basically, it's the one last time speech. Let's have one last time, right? I mean, come on. We're adults. We know how the game is played. We know how this goes. And that's exactly what that was. This wasn't a woman who said in that audio that this was not a woman who testified that on May 21st she realized it was her or him, right? this was going to end very, very badly if she didn't do what she did. She was resolute and resolved in seeking and filing a divorce. And one could make the point that, and she probably will, that the email or text exchange where she is walking back the TRO, the calling of the police, the filing of the restraining order, etc., to Johnny Depp and pushing it off on her attorneys, one could make the argument that she did that because she feared his wrath, both in every sense of the word, right? Okay, you could make that point, and that might be a good point, except for the fact that she initiated contact, met with him, all of the things. Period. That's it. And then you have the, in my opinion, the true Amber Heard, what she really thinks, how she really felt, and the truth of this entire matter. The audio where she says, "Go ahead. Tell them it was a fair fight. Tell them you, as a man, Johnny Depp, are the victim of domestic violence. See if they believe you." That is the truth of the matter, which we're all here. This is what we're all here about. Hey, Betty's Beauty. Exactly. And the truth is that not all physical abuse results in bruises. Okay. However, if somebody punches you in the face repeatedly with essentially what amounts to brass knuckles, because if you have a ring on every finger while you're making a fist and you're hitting the person with your fist in their face, there's going to be bruising. There's going to be marks. There's going to not just be bruising, but cuts. Think about a boxing match. What are boxers using? Their hands, and what are their hands covered with? A glove. There's no sharp, pointed, odd part of a glove, but you can, if you hit the same spot enough times, cause a cut. The skin gives way. Period. So if he's wearing rings, there would be cuts, there would be bruises, there would be swelling, and nobody can testify to that, as well as no one can testify that they witnessed anything physical between Johnny Depp and Amber Heard. So you're telling me on Thanksgiving there was a whole ass brawl upstairs, and you, her friends, are sitting at a table hearing a brawl going on upstairs, and none of y'all think to intervene? None of you do? After allegedly you have seen bruises on Amber Heard before, so you have some knowledge, at least, that there's been a potential in the past for violence. You don't think that you would go up, you don't think that you should go up there and intervene? But this is the 2000s, not the 1950s. In the 1950s, you're 100% correct. People would be sitting at that dining room table enjoying their Thanksgiving meal. I don't know about enjoying it, but eating their Thanksgiving meal, and their stance would have been, "My name is Paul, and that's between y'all." And nobody would have intervened in a domestic fight. But that was then, and this is now, and people know better and they do better. And you guys didn't think, if nothing else, he chunked a huge, very gorgeous antique decanter at her. You didn't hear that? You didn't think, "Holy moly." At the bare minimum, you hear a crash, right? You don't think maybe you should go and check on your friends? What if somebody fell? What if it wasn't a brawl? What if it was simply a I've fallen and I can't get up situation? You can't be the life alert for your friends? What kind of friends are you? Not the kind of friends I would want to have. And how come you're not friends anymore? Why has every person who was integral in the reporting and testifying to the physical abuse of Amber Heard no longer associated with Amber Heard by their own choice? It isn't like Amber Heard said, I don't think this is working out. It's not you, it's me, and we can't be friends anymore. She's not the one that ended friendships. They ended friendships. They ended their friendships, and the makeup artist ended a working relationship and I suppose a friendship of sorts. And that's the truth. And that's what happened.
All right, are we ready for the jury then?
Yes, Your Honor, we're very ready for the jury. Jen has been on a whole rant, and we wish that she would just stop. Oh, she just makes me, this whole situation just irks me on a cellular level. And for the record, every bit of my opinion on this case has been formed by the evidence presented in this case. I don't give a rat's fat kneecap about Twitter, about the tickety talks, about YouTube, about Twitch, about Facebook, or any other social media platform. My opinions on this case have been based on the evidence presented in this case. The end. Okay, now I'm going to behave.
All right.
That's a distinct possibility, Sarah.
Good morning, ladies and
An
gentlemen. I apologize.
absolute.
We have a few housekeeping matters to take care of, but thank you. You can have your seat. All right, your next witness.
Your Honor, on behalf of defendant and counterclaimant Amber Heard, we rest.
All right, thank you. All right, rebuttal evidence?
Yes, Your Honor, Mr. Depp calls Walter Hamada of Warner Brothers.
All right, Mr. Hamad.
Your Honor, just to clarify, this is by deposition, so we may
Oh,
need that.
okay, well, okay.
I apologize, I should have provided notice.
That's all right.
Thank you, Your Honor.
If we could, yeah.
Did they say this was going to be video testimony? Is that what they said? My ears are ringing from my speechifying.
Ramada, what do you work for Warner Brothers Entertainment Inc.?
Yes, I do.
I'm going to mute. I'll be right back. Please behave
My title
yourselves.
is President of DC-based film productions for Warner Brothers.
What, if anything, you did to prepare to testify for Warner Brothers as to topics 2 through 18?
I did not do anything to prepare for this, other than the meeting that I had with the attorneys.
Did Warner Brothers have a contract with Amber Heard to perform in Aquaman 2?
Yes, there was we had an option agreement for her for Aquaman 2.
Do you know what it is?
It looks like a standard contract between an actor and the studio.
And which actor was involved in this? Which actor was a party to this contract?
Amber Heard. It's a contract for Amber Heard for the role of Mara in Aquaman and its sequels.
Which studio contracted with Amber Heard?
Warner Brothers.
When did you come to be the president of DC?
At the beginning of 2018.
Mr. Hamada, was Ms. Heard ever released by Warner Brothers from the Aquaman 2 contract, or what you call the option agreement?
No.
Was she released from her Aquaman 2 contract on or about February 22, 2021?
No.
Was Ms. Heard ever rehired for Aquaman 2 by Warner Brothers?
No.
Did Ms. Heard receive a pay increase for Aquaman 2?
No.
Why not?
As a rule, as a company, we go through a lot of trouble when we make our deals with our actors. We get options on them for subsequent movies. And I think traditionally, prior to me joining the company, every option was renegotiated. And one of the things that we were trying to put a rein in on was not renegotiating every deal, with the understanding that people come in and make these deals and they have an understanding that there will be options and that there is a deal in place. And it was a big part of our philosophy that we were going to hold people to their options moving forward.
But did Warner Brothers at any point in time reduce Ms. Heard's role in Aquaman 2?
The role in the film the size of the role in the film that she has was determined in the early development of the script, which would have happened in 2018, I would say.
Well,
So and from there, beyond normal development, the role sort of, the character's involvement in the story was sort of what it was from the beginning.
was her role ever reduced for any reason?
No, I mean, again, from the early stages of the development of the script, the movie was built around the character of Arthur and the character of Orm, Arthur being Jason Momoa and Orm being Patrick Wilson. So they were always the two co-leads of the movie.
Did Warner Brothers ever plan to portray Ms. Heard as the co-lead in Aquaman 2?
No, it was the movie was always pitched as a buddy comedy between Jason Momoa and Patrick Wilson.
Was Ms. Heard cast in Aquaman?
Yes, she was.
Was Ms. Heard cast in Aquaman 2?
Yes, she was.
Was Ms. Heard paid for her services in Aquaman 1?
Yes.
Was Ms. Heard paid for her services in Aquaman 2?
Yes.
Was her compensation for Aquaman 2 affected in any way by anything said by Johnny Depp?
No.
Was her compensation for Aquaman 2 affected by anything said by Adam Waldman?
No.
Was her compensation for Aquaman 2 affected by anything said by anybody representing Johnny Depp?
No.
Was there any delay in Warner Brothers exercising the option to cast Ms. Heard in Aquaman 2?
Yes, there was.
How long a delay was there?
I don't know, probably weeks.
What was the cause of the delay?
There were conversations about potentially recasting.
Who was the producer?
Peter Safran,
Who was the director?
James Wan.
Did Warner Brothers believe that those concerns were legitimate?
Yeah, I mean, I had no reason not to believe the director and the producer of the movie.
And you are testifying today as a representative of Warner, correct?
Yes, I am.
What, if any, creative concerns did Warner Brothers have about casting Amber Heard as Mira in Aquaman 2?
It was the concerns that were brought up at the wrap of the first movie, production of the first movie, which is the issue of chemistry. Did the two have chemistry? I think editorially they were able to make that relationship work in the first movie, but there was a concern that it took a lot of effort to get there. And would we be better off recasting, finding someone who had better, more natural chemistry with Jason Momoa and move forward that way?
Did Warner Brothers take any steps affirmatively to audition other actresses for the role of Mira in Aquaman 2?
No, we did not.
Other than the creative concerns and concerns about chemistry you testified about, was there any other reason Warner Brothers delayed in picking up Ms. Heard's option for Aquaman 2?
No, it was all concerns about whether she was the right bit of casting for the movie.
What role, if any, did Ms. Heard's dispute with Johnny Depp have in Warner Brothers' delay in picking up Ms. Heard's option for Aquaman 2?
There was none from our end.
At any point in time, was Warner Brothers considering paying Ms. Heard more money for Aquaman 2 than is set forth in the option contract you previously identified?
No, as I said, we were determined to hold our actors to their option agreements.
Would Warner Brothers have paid Ms. Heard more money on Aquaman 2 if it had picked up her option earlier?
No.
At any time from the beginning of history through today, did Warner Brothers ever release Ms. Heard from the Aquaman 2 contract?
No.
At any point in time from the beginning of history to today, did Warner Brothers rehire Ms. Heard for Aquaman 2?
No, because we just picked up her option.
And when is the last time you spoke with Rob Cohen relating in any manner to whether to exercise the option on Amber Heard for Aquaman 2?
No, it would have been the same time that I was having those conversations with Peter Safran.
So
In 2020.
did you speak with Zack Snyder at all relating to whether to exercise the option for Amber Heard on Aquaman 2?
No, I've not had any conversations with Zack Snyder.
Did you speak at all with Jason Momoa in preparation for your deposition today?
No.
Have you ever spoken with Jason Momoa about any issues relating to chemistry between he and Amber Heard?
Yes.
When did you speak with Jason Momoa about chemistry issues between he and Amber Heard?
It would have been in that same time period where we were prior to green light of the movie.
Now, you were asked some questions about scripts. Did you review any of the drafts of the script for Aquaman 2?
Yes.
When?
I part of my role is I read all the drafts of the scripts as they come in.
When was the first script for Aquaman 2?
Oh boy. I cannot tell you. Probably in 2018, the latter part of 2018 would be my guess.
And how many versions of the script had been written by the beginning of 2021 for Aquaman 2?
Oh, there were probably half dozen drafts of the script. I don't know.
All right, what, if anything, did Rob Cowan say to you about chemistry? What specifically about the chemistry between Amber Heard and Jason Momoa?
Just the fact that they didn't really have a lot of chemistry together. The reality is it's not uncommon on movies for two leads to not have chemistry, and that it's sort of movie magic and editorial, the ability to sort of put performances together, and with the magic of a great score and how you put the pieces together, you can fabricate sort of that chemistry. And so I think in at the end of the day, I think if you watch the movie, they look like they had great chemistry. But I just know that through the course of the post-production that it took a lot of effort to get there. Sometimes you don't. Sometimes it's very easy. You just put the characters on the screen together and they work. And sometimes it's harder. And so,
can you give me anything more specific about what it was with Amber Heard and Jason Momoa that was difficult for the chemistry?
No, because it's like what makes a movie star a movie star. Like you know it when you see it, and the chemistry wasn't there.
Now, you've used the term fabricated a number of times. What did you do to fabricate the chemistry between Amber Heard and Jason Momoa?
Well, those are just, it's editorial. A good editor and a good filmmaker can pick the right takes, can pick the right moments, and put scenes together. Again, score is a big, the music in a scene makes a big difference. It can make a happy scene feel sadder or a sad scene feel happier. And so it was sort of it's just the magic of post-production, editing, sound design, music, etc.
What do you mean by fabricating, though? I mean, were they literally falsifying, or were they just picking the best music? Let me just finish my question. Were they picking the best music and picking the best looks because that's their job and that's what you do on every scene?
That is what we do in post-production. That's what filmmakers do. This is on any production. You're doing that. You're putting performances together. Sometimes it's easier than others. This one was more difficult because of the lack of chemistry between the two. But they were able to, James Wan and the editor were able to get it to a place where the end result actually works, and it's great.
And in fact, that's the job of every filmmaker, right? Is to put all the combinations together to make the most successful production.
Absolutely.
I'll tell you what has been marked as exhibit number 5. It's ALH 18247. And this is a text message exchange between James Wan and Amber Heard. And you mentioned James Wan was the director of Aquaman 2. Is that correct? And Aquaman, and Aquaman, the first one, correct?
That's correct.
All right. And James is texting to Amber on August 25, 2018. You rated really high with the audience, exclamation mark, exclamation mark. Do you see that?
Yes.
This is August 25, 2018. What's going on August 25, 2018 that would cause the director to send a text message to Amber saying,
that'd be a test screening. So during our post-production of the movie, we test the movie with an audience, and the audience tells us what they liked and what they didn't like. And so that's what he's referring to there.
And they really liked Amber Heard, correct?
Yes, she did. She tested well.
It hit $1 billion, is that correct?
Yeah.
And more specifically, did you play any
Testing well with a screening audience is not the same as testing well with the rest of the viewing audience. And the rest of the viewing audience didn't like her. And it had nothing to do with the situation with Johnny Depp. It was her.
Offered to reach out to the agent and express which direction we were leaning.
Have you seen any document that says there was any chemistry issues between Amber Heard and Jason Momoa in Aquaman 1?
Documents? No, I mean, those were all conversations.
But if Jason came back...
It's not like they keep an HR file to that.
Correct?
That's correct.
Sorry, you guys missed the
And
question.
Jason Momoa was able to negotiate a different compensation structure, was he not, for Aquaman 2?
That's true. He did renegotiate.
Now, Aquaman was the highest grossing DC film ever for Warner Brothers, was it not?
Yes, it was.
What, if any, issues
Here we
did you have
go.
with Amber Heard in Aquaman 2?
My understanding is actually the production went very smoothly.
All right, thank you. Your next witness.
Your Honor, we call Dr. Colbert next, but I know we have a preliminary matter that we need to deal with briefly, if we may approach.
Sure.
Let me just do a little research and investigation. Please hold. I'll be right back. So while we wait for their sidebar, Elaine, they don't keep like HR files, right? It's not. This is a different kind of work environment, and they would not keep like an HR file of coworkers' complaints against one another. So there probably would not be some type of paper trail, excuse me, respective to Amber Heard's chemistry or lack of chemistry with Jason Momoa. Okay. It's not like after production wraps, they sit down for a formal, the cast sits down for a formal exit interview. Okay. Give me a break. Elaine. Okay. I'm going to search right now for the Justice League to see if both versions are available. I know the redone version, the remake. It's not really a remake. It's a I don't know how to explain it. It's a reworking. It has Zack Snyder's original ending, and hold on. So I'm going to see if both versions are available on the HBO Max. And if they are, I will watch them. And I will, oh yeah, they're both available. So the original version of the Justice League is 2 hours long. And Zack Snyder's, I feel like, is closer to okay. Zack Snyder's is 4 whole hours and 2 minutes. Okay. So because I love you guys so much, I also love the Justice League. I'm going to do research and investigation, and I will be more than happy to time approximately as best I can Amber Heard's screen time in both versions. And then that will tell us what the score is and how Zack Snyder felt about Amber Heard's performance. Also, Chick Tracy, I think that you should be able to watch the Justice League, both versions, probably on any paid streaming service. Like it would be available on Vudu, Amazon, Apple, any of those streaming services, you could probably rent it fairly reasonably priced. Maybe not the remake or the redo, the rework, I guess is what you'd call it. That one might be a little bit more expensive, but you know, I don't know if they're offering a discount on that. I mean, if you haven't seen Zack Snyder's Justice League, you should, because it is so good. So good. I mean, the original is good too. It's really good. But I I really like Zack Snyder's version as well. And the fact that it's 4 hours long, this is the thing. Like there are certain directors that when you go see one of their movies that you're going to be there for a while. Like Oliver Stone, Peter Jackson, who's another one? Hold on, let me Google out because his name is on the very tip of my tongue, and for whatever reason, I can't quite get there. Hold on a second. Martin Scorsese. You know that they're going to be there for a minute, and the thing is the fact that I didn't even realize. Yes, Christopher Nolan, another good one. Good example. The fact that I didn't even remember that it was 4 hours long tells you something. Because I'm keenly aware of movies that are long while simultaneously not being good. Like we've all talked about this. I'm not Halloween Kills, right? So Halloween Kills got a lot of negative feedback because it is long for a horror film, okay? But I think what people forget is that it's the middle part of the story. No, it's no different than The Two Towers is the middle of the story in the Lord of the Rings trilogy, or The Desolation of Smaug is the middle of the Hobbit trilogy. So the middle ones tend to sometimes lag a little, but they're very, very important in the overall trilogy. Empire Strikes Back. Okay, that's the middle. But they have this whole big long thing where Luke goes and sees Yoda for the first time, and there's the game playing, and blah blah blah. We've all seen it, right? But then there's this weird part where he goes in that like cave thing that he goes. I think, yeah, that cave thing that he goes into, and it's sort of it's longer than it needed to be, but but once you watch all of them, once you see the third one, right, then you're able to put the pieces together, and especially with then when they released finally the first, second, and third parts of the story that pertain to Anakin, then that part in the cave makes sense, right? But at the time, it feels kind of unnecessary and a little too long, right? And so I'm keenly aware of films that
Ladies and
way.
gentlemen, I apologize again. We have a few things to take care of. We're just going to go ahead and take our morning recess now for 15 minutes. Do not discuss the case.
Bruh.
Okay? Do not do any outside research. Sorry, that was the same thing.
Okay. So, yeah, so many sidebars. But anyway, so bottom line is this. I give it 2 very enthusiastic thumbs up. I recommend everybody see it. It's very, very good. Also, as with all either DC or Marvel,
All right. All right. We'll Go ahead.
movies, you should always um, stay or watch until the end of the credits, because there's always some little Easter egg dropped, and those are always very cool if you're a fan. But even if you're not a fan and you're new to it, it will make you become a fan. You should definitely check that out. And also, I thought this was a good rebuttal witness to start with, because, of course, this goes again to Amber's counterclaim, which is that due to Mr. Waldman's statements that were defamatory, she lost out on Aquaman 2, and not completely, but they made her role incredibly small. And yes, Max 2002, basically, in a nutshell, Amber didn't have chemistry with Jason. And the truth of the matter is, with respect to that role, Mira, okay, her role in the film, right, or in the story, is to convince Aquaman to get involved, okay, in the fight for Atlantis. All right. And so there are some, or would have been, I don't know how to put this. Let me think about this. What you would expect is some scene where there's like an emotional plea from Mira, played by Amber Heard, to uh, Aquaman, played by Jason Momoa, to convince him. And there is that scene. Just watch it. That's all I'll say about it. And, I don't know Jason Momoa personally. We're not friends. He doesn't follow me on social media or anything like that. Doesn't slide into my DMs. We don't kick it on the weekends. And I realize that watching social media, only gives you a glimpse. And of course, it's the highlight reel of anybody's life, right? But I have seen other things with Jason Momoa, like, red carpet and, arrivals and interviews and stuff like that. And generally speaking, he seems to be kind of like this down to earth, kind of chill guy, and pretty much gets along with just about anybody. And the fact that there was, no, and he was supportive in to Amber Heard through social media. And so the fact that he's no longer following, I know, see, cement shoes. I keep checking and refreshing my DMs, but no Jason Momoa. It's sad. But anyway, he seems to be like a decent guy. Obviously, goes without saying, nobody is perfect. Everybody has a little something. But generally speaking, he seems to be a decent guy. And he was at one point very supportive of Amber Heard with respect to her ACLU ambassadorship and all of that. And then now he is not following her, which I think speaks to more. Okay, so there's been a lot of argument on the YouTubes and other platforms, right, that people's opinions have been influenced by this smear campaign, right? Where certain things are released and they're skewed in such a way that they make Amber Heard look bad, right? We've all heard that that allegation, right? There's been more than one person who has that opinion, and that's fine. But he didn't start. He didn't stop following Amber Heard until I feel like about the time that Johnny Depp testified, which to me is more indicative of he is watching the trial. He is hearing the evidence, and he is forming his own opinion because he didn't stop following her, right? And then begin following her again after her testimony, did he? So if he were being influenced unfair, if he were being influenced, if by the smear campaign, yada yada yada, um, one could argue that when Johnny Depp testified, he found his testimony so compelling that he unfollowed Amber Heard, right? But then, upon hearing Amber's testimony and evidence presented on her behalf, right, that he then had more information and made a different decision, which is normal, which is the way people typically do, right? Most people form an opinion, and as more information comes in, either it confirms their original opinion or their opinion changes. That's how it works. But he didn't, which tells me that nothing that Amber testified to or that has been presented on Amber Heard's behalf has swayed his opinion. It hasn't changed his opinion. In fact, more celebrities have now rallied to support Johnny Depp. So celebrities that had, for the most part, stayed out of this. They had taken the "my name is Paul, that's between y'all" position. And after the further along the trial got, more evidence that was presented, more and more celebrities followed Johnny Depp and were more vocal in their support of Johnny Depp. And so I think that speaks to um, the impact any alleged smear campaign had on celebrities and regular people. Because, of course, there's going to be that element that watches things and takes it at face value. That happens all the time. And I mean, I don't judge. Everybody does things their own way, right? But I think that I can only speak to me personally. I didn't look into a lot of the backstory with respect to this case. And I I wasn't I mean, I do have a Twitter account. I have a personal one, and then the Ward Case Studies has a Twitter account. I never tweet. I don't tweet, and I haven't retweeted in a long time on my personal account. But anyway, that's beside the point. I wasn't influenced mainly because I didn't see it. Now, after the fact, after the trial has started, obviously, older tweets have resurfaced. Other stuff from social media has resurfaced, but it hasn't swayed me in any way, shape, or form. My opinion has been based on the evidence. And going into this trial, I was 100% open to hearing Amber Heard's evidence. I wanted to hear her testify. I wanted to hear her story from her mouth. Um, I wanted to see what she was going to present to back up her testimony and her account of things. And I have formed my opinion based around the evidence presented in this trial, not on. Do I enjoy the TikToks? Yes. The truth is that the TikToks that are pointing out certain things with respect to Amber Heard, they are funny. They're meant to be funny. They're not meant for you to base your opinion of Amber Heard on a what, 35, 40, maybe a minute long tickety talk. Exactly, Max 2002. Exactly. Exactly. So why didn't, if Amber Heard has all of the proof and the evidence that Mr. Waldman, working in conjunction with Johnny Depp, cons- conspired, what's the word, colluded to start this massive smear campaign against Amber Heard and paint her a liar when she was really the victim of domestic abuse, right? Or violence, right? Why then didn't she sue Mr. Waldman? Why didn't she? You have to wonder. I mean, everyone, Mr. Rottenborn had made a point multiple times throughout this trial, but particularly in his opening statement, that Johnny Depp did not sue the Washington Post. And why didn't he sue the Washington Post? I think the reason he didn't, I think that, first of all, it probably wouldn't have been successful, but more to the point is that I think what he showed, in my opinion, with the Mr. Doherty from the ACLU, that there was um, a plan. I won't go. People always, when you use the word conspiracy, it takes a different meaning for people. It has a different connotation. So what I will say is a plan. Um, that was I mean, that has been proven that there was a plan to make it very okay. They never directly named Johnny Depp in the op-ed, but the wording of the op-ed makes it very, very clear that the op-ed is about Johnny Depp. Exactly, Michelle. Like, you can go and watch the TikToks, and they're funny. The truth is, they're funny. The ones where they come up with something in response to, my dog was stung by a bee. Those are funny. Hey, Coolest Reviews. And you can enjoy them for what they are, which is humor. Hope you're well. I'm good. How are you? You know, that doesn't mean that you should, I would not suggest those be the foundation for which your opinion is based. I would suggest that you watch the trial, you hear the evidence, you watch, the testimony, yada, 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 and you decide for yourself. I wouldn't, let's see what Amelia said, and that they wanted it to sound like it was JD and people to think it was JD without saying his actual name, and they celebrated when it worked. Absolutely. Absolutely. That's exactly what happened. And that is exactly what Mr. Doherty testified to. And the proof of that is the email chains, period. It isn't like Mr. Doherty got up there and just gave testimony, right? The testimony is backed up by the email chains, which is important. There's, brace yourselves, corroborating evidence. And that's what's important. So I don't even remember now when this break started. It feels like forever. I feel like I have talked more during this day of testimony and trial than any other day. Do you guys feel like that? I feel like I have. Oh, crap. Amelia called Jinx on me. Somebody say my name so I can talk. I don't know. I do be keeping it real. Coolest reviews. I don't know anywhere. Like, look, I just say what I think. I mean, I will. The only thing I do as far as censoring myself is I try not to um, just have a sailor's mouth. Although I do come from a sailor. Um, my dad was in the Navy. But I try very, very hard not to just drop the F bomb right, left, and center. Because frankly, if you want to know the truth, the F bomb is my actual favorite cuss word because it can be used in so many different ways. It can be used as a verb. It can be used as an adverb. It can be used just as a conjunction. It can be used so many different ways. Oh, thank you, Sarah. I hope I always I hope that my explanations are good and I'm glad that you are enjoying them because I try to break it down as best I can. Like I'm not super duper familiar with the whole civil case, right? Like I don't really know a lot about civil cases but I've been learning as we go with you guys and I've learned quite a few things. Yes. Sometimes you just gotta say "F it." Well, thank you, Amelia Sparkles. I'm glad you guys are appreciating my commentary. I try. You really do, coolest reviews. See, using that word does lose impact if you use it all the time, kinda like crying. See, I'm not a big crier because kind of the way I was raised, right? My dad was just, one of those dads who it was difficult for him to listen to your listen to an argument, right? Or you make your case if you're crying because if you're crying, he felt like you were emotional and therefore not having rational thoughts. So your argument was irrational. So I kind of learned from that. So, but I also as a side effect of that, realized how I don't cry very often, but when I do cry, people be paying attention because they're like, "You never cry, and you're crying. This must be serious." It's kind of like that. Aw, you guys. You guys are so nice. I appreciate that. Thank you. I do. Sugar Beet, I didn't actually, oops, I highlighted the wrong one. I didn't actually watch the civil trial. Oh, Chick Tracy, could you come? I have a self-cleaning oven, but I never think I never think that it works as well as when you get in there with the oven off. That's the favorite one I like to use. Nothing works as well as oven off. So, yeah, this seems like the longest 15-minute break ever. I'm sorry, you guys. I'm a little parched. Oh, we're back.
All right. Yes, sir. Okay. Approach. Ms. Myers.
Oh, thank you, Shmeda. I've had to adjust my routine. Normally, I get up, I have my coffee, I have my 5 hour. I see what's going on around the world, and then I wash dishes from breakfast and straighten up around the house, vacuum, that kind of thing. Um, and I've had to adjust my schedule for the streaming, and I'm actually liking my new schedule better. After I get off of here with you guys, I think he is actually because and I'm not being critical. This does happen. He looks around the midsection to have what's commonly referred to as I do love me some lemon plish. Um Lemon plish, fabulosa, and Avenoff. Those are my favorites. He does look to have a little bit around the midsection, what people commonly refer to as a little sober bloat, but that'll come right off. He looks very, very healthy, and he looks, I think, more relaxed today than at any point, quite frankly, in this trial. Oh, yes, coffee is an absolute must. I cannot function without my coffee, which is weird because growing up, my parents were, well, they still are, not my mom because she's passed away, but coffee drinkers, right? So my mom would get up because she was a histologist, and that she would have to be at the hospital like by 6 o'clock in the morning. So she got up like, I don't know, probably about 4 o'clock because she liked to have time to have her coffee and wake up a little bit and then get cleaned up and then, head to work and whatnot. So then she would come home in the afternoon and have iced coffee, whatever was left in the pot, right? She would pour over iced coffee. And then at night, they had their decaf coffee. And so my sister and I were usually responsible for the evening coffee. My mom taught us how to make it. My mom taught us how to reheat coffee cups. But the thing is that my mom, working as a histologist, she became really sensitive to fluorescent lights. And so in the morning time, she would not turn on the kitchen light, which was a fluorescent light. She would turn on the light over the stove, which was not enough light. And so Jules, my sister and I would get up in the morning, and it would be our responsibility to straighten up the house before we left for school. And one of those things was we would make our own breakfast, right? Because my mom worked, and, clean up after that. But my mom invariably always left coffee grounds like in a line on the counter, and we were always cleaning it up. And we were so annoyed by that, that we vowed we would never be coffee drinkers. And now both of us
Sir, can you
are
hear me?
devout coffee
Can you
drinkers.
hear me? Yes, can you
Okay.
count to 5 for me?
1, 2, 3, 4, 5.
All right, I'm be quiet.
I'm just trying to get you on the big screen. We're waiting for the jury. Just give us a minute, okay, sir?
Thank you.
Oh, excuse me, Your Honor, whilst we wait for the jury, can we work on the audio issues? It's very low. And just as a side note, I know that my mom is somewhere chuckling at the fact that my sister and I were so
Thank you.
staunch
Proceed.
in we'll never be coffee drinkers, and now we are.
Dr. Kolber?
All right, sir, if you could raise your right hand. Do you swear affirm to tell the truth under penalty of law?
Yes.
Your Honor, I would just object that Dr. Culver appears to have a stack of documents right in front of him.
All right, sir, you can put your hand down, and any documents you have, if you could put them away and just testify from your memory, okay, sir? Thank you.
Thank you, Your Honor.
All right, your question?
Good morning, Dr. Kolber. Could you please state your full name for the record?
David Allen Colbert.
And what is your profession?
I'm a plastic and hand surgeon.
And how long have you been a plastic and hand surgeon?
Been in practice for 26 years
Where do you currently work?
at Cedars-Sinai Medical Center
How long have you worked there?
for the past 26 years.
Do you know the plaintiff in this action, Johnny Depp?
I do.
And how do you know Mr. Depp?
I had taken care of him when he had injured his hand.
When did Mr. Depp become your patient?
sometime in March of 2015.
And what type of treatment did you provide to Mr. Depp?
He had a fracture of his finger with soft tissue loss. And so we reconstructed his finger.
When did you perform the first surgery on Mr. Depp's finger?
I believe it was around March 20th of 2015.
And what was involved in that surgery, just briefly?
Debriding the vitalized tissue, putting a hypothenar skin graft, store some of the soft tissue loss that he had, and then also putting a pin in because he had a displaced distal phalanx fracture.
What was the state of Mr. Depp's hand immediately after that surgery? I'm sorry, I think the audio cut out a little bit. Could you please repeat your answer?
It was injured and had soft tissue loss and a fracture of his distal phalanx.
And what type of cast was on Mr. Depp's hand after you performed that surgery?
It was a plaster splint.
And can you please describe to the jury what a plaster splint would look like?
So it's like a cast, but you don't want to put everything circumferential on it because of swelling after surgery. So I believe in Mr. Depp's case, it was like the two fingers. I think the third finger was the one that was operated on. So these two fingers, the third and fourth finger together, and it's a splint with plaster on the top and on the bottom that goes around the hand to protect it.
How mobile was Mr. Depp's hand when it was in that cast?
Well, he couldn't move his third and fourth fingers because of the bulkiness of the splint. Typically, post-operatively, it's a more bulkier splint right after the surgery. So it's not very, it gets in the way.
Could Mr. Depp grab someone with that cast on his hand?
He could attempt to grab someone. I don't know how successful he would be. He had his index finger free and his thumb free, but the other fingers were probably not being able to move.
How long was the pin in Mr. Depp's finger?
About 11 or 12 days.
And how was the pin removed?
It was removed under local anesthesia in my office.
How long did you ultimately treat Mr. Depp for his hand injury?
For several months.
And why was that?
It was a bad injury. It required a few more little office procedures to clean up the tissue. He had an infection as a result of the injury, so he had to be on antibiotics for some time until it finally completely healed.
Do you recall when the infection developed?
It was a few weeks after the surgery, and that's when I took out the pin.
When was the last time that you saw Mr. Depp?
Sometime in 2015. I don't recall when.
And when was the last time that you spoke to Mr. Depp?
The same, around 2015.
Thank you, Dr. Colbert.
All right, cross-examination.
Good morning, Dr. Culber. So you said that this plaster splint was put on after surgery on March 20th, 2015?
Yes.
And a plaster
Yeah.
a plaster splint, is that sometimes called half a cast?
Sometimes it's called half a cast or a soft cast, something like that, yeah,
And it's made of plaster of Paris, right?
correct.
And plaster of Paris hardens like a cast does, correct?
Yes,
So other than the fact that it's a little smaller than a cast that goes around your whole hand, it's just as hard as a cast that would be put on a broken arm or a broken hand, correct?
well, it's softer on the side so the fingers can expand for swelling. So it's not fully, the plaster appears circumferential around everything. So there are areas that are softer to allow for swelling.
But the parts that are covered with plaster of Paris are just as hard as any other cast, correct?
Correct.
And regardless of whether Mr. Depp could have grabbed someone with the hand with the cast on, he could have grabbed someone with the hand without the cast on, correct?
Correct.
Michelle, can you pull up Exhibit 400, please? This has been admitted, Your Honor.
All right.
Permission to publish.
Yes, yes, sir.
Dr. Culber, I'm just going to ask Michelle here to just scroll through these pictures, and I'd ask you to take a look at them.
Your Honor, I'm going to object for lack of foundation for these photographs.
They're already in evidence.
With respect to the questions to the witness.
They're in evidence. Thank you.
Michelle, if you could go back up to that, stop right there. Is there anything about the cast that was put on Mr. Depp's hand on March 20th, 2015 that would have prevented him from doing this damage to Ms. Heard's closet on March 23rd, 2015?
Objection calls for speculation.
Overruled.
I mean, he had his other hand available. So,
No further questions. Thank you.
All right, redirect.
Dr. Culber, how many fingers were in the plaster portion of Mr. Depp's cast?
I believe 2 or 3, at least 2 were, and the third one and the fourth one.
And why did you call it a soft cast?
Because it's not fully, plaster doesn't go around the entire hand because you allow for swelling. So there's plaster to protect the fracture. So there's a little plaster on it, but it's on the top and the bottom, but it's not completely circumferential. So there's soft spots to it.
And where are those soft spots located again?
Usually we'd put a piece of plaster underneath the fingers and on top, and then the sides of the fingers, it's soft so that the fingers can swell after the surgery.
Could Mr. Depp have hit someone with the hand that had the cast on it?
He could have hit someone with it. It probably would have injured, damaged the cast.
Did you ever notice any damage to Mr. Depp's cast when you treated him after the surgery?
I don't recall. But nothing that comes to mind.
Could Mr. Depp form a fist with the cast on?
No.
No further questions. Thank you, Dr. Kohler.
All right, thank you, sir. That concludes your testimony. Thank you. All right, your next witness.
Plaintiff calls Richard Marks, Your Honor.
All right, Mr. Marks. So just a reminder
Sorry,
that
ma'am.
you're. Hold on. One minute. Just give us a second and see. No, sir, you've already, just a reminder that you're still under oath. Okay, sir?
Sorry, you guys.
All right. Good morning, sir. All right. Yes, ma'am.
Thank you, Your Honor. Welcome back, Mr. Marks. You've testified in this case previously, but would you just briefly remind the jury who you are?
I'm Richard Marks, and I'm a full-time entertainment transactional attorney. I make deals every day for productions and for individuals. I'm in the trenches negotiating and then making sure the contracts reflect the deals. And I'm very much distinguished from the other side's expert who is not an attorney, who's not in the trenches making deals, is not in that day-to-day process.
And are you familiar with the testimony of Catherine Arnold in this matter?
Yes,
Have you been asked to analyze that testimony and provide opinions in response?
yes.
And generally, what are those opinions?
Well, my opinions are that she's very slick and smooth, but she's not an expert in deal making. Her assessment of damages is built on nothing, and it's wildly speculative.
Are you familiar with Ms. Arnold's opinion that it's customary for an actor to renegotiate the fee for a subsequent picture option in a multi-picture contract when a film is successful?
Yes, I heard that opinion.
And are you also familiar with her testimony that under those circumstances, an actor will renegotiate a 50 to 100% increase in their salary for the next optional film?
Yes, I heard her say that.
Do you agree with those?
Hi, I've learned a lot.
Absolutely not.
Why not, sir?
Well, what we're dealing with in this case is a test option agreement. And that's an agreement, it's a multi-picture agreement, and it's the nightmare for people like me. The test is going to take place, let's say, for 10 actors the next morning at 9, and you have to fully negotiate a contract that might cover 4 movies and have it signed before they're allowed to test, so that if they're chosen for the part, we have the full contract. There's no renegotiation. So you've got a contract for a multi-picture deal. It's usually a franchise, and you negotiate the first movie. And normally, if they get the part, they're the chosen one. They're the Stars Born moment, if you will. They get the part. Normally, their salary is inflated from their normal salary, because now they're going to play a character that could go on for 4 movies. In this case, Ms. Heard's first salary when she got the part was $450,000. If Warner Brothers and DC Comics decided to make a next movie, they could recast her. They had no obligation. All they had was an option. But if they did cast her up front, that they had agreed to more than double her salary, like 2.25 times to get to the $1 million. These are large bumps, if you will. If an actor is on a series, say, they go, and they have 5 options. They go up in increments of 5%, 10%, 20%, not these multiples that you see in a test option agreement. And that's one of the reasons that they aren't renegotiated normally. They are in some instances, but not normally.
What's the significance of the test part in a test option agreement?
The test significance is that an established actor usually wouldn't test. They'd be offered the role. Ms. Heard was in a group of actors that needed to be tested to see if the studio wanted to hire them. And then if they hired them, they would be locked up for potentially 4 movies at very lucrative increases, because after Aquaman 1, she gets to $1 million. Aquaman 2, she gets to $2 million. And Aquaman 3, excuse me, you get to $4 million. These are unheard of bumps if you're going on a normal career and trying to increase your salary by increments.
In your experience, what is customary for negotiations of multi-picture deals?
Well, I think what happened in this case was customary for negotiation of multi-picture deals. And by that, I mean that you assume success. The reason you go from the first Justice League movie where Miss Heard played Mira the first time, the reason you more than double her salary is you assume success. So you've already built in the bonus that Miss Arnold was referring to, a renegotiation, if you will, for the third movie. Instead of doubling her salary, Miss Arnold said it would only be fair to quadruple her salary. And that's just not the way these idiosyncratic contracts work. They're a very small portion of the contracts we deal with.
Are you familiar with Ms. Arnold's opinion that Ms. Heard's salary for Aquaman 2 could have been renegotiated to around $4 million?
I am.
Do you agree with that opinion?
No.
Why not?
Well, as I've said, that would now be after a healthy first payday. It's more than doubled, and now it would be quadrupled. That's not the way it happens. Walter Hamada, who is the president of that part of the studio, said it doesn't happen. They're not going to do it. Miss Arnold, for some substance, says, well, Jason Momoa got to do it, but she doesn't give us any of the details. We know that Jason Momoa was in a movie before the Justice League. He played Aquaman in a movie not with Miss Mira in that movie. So he had a history before the first movie with Amber Heard. He played Aquaman. We don't know what his contract, the state of it was when you got to Aquaman 2, and she says, unsupported, that he renegotiated. We're not sure what he renegotiated to. But I can say that at the end of the option period, when you've only got one option left and you want that star in more movies, you may renegotiate, but it's not a gratuity. It's, we'll give you more for the last option if you'll give us 3 more options. It's a give and take. And unfortunately, Miss Arnold didn't give us any of that background or those building blocks. And then I think yesterday she said, and the other actors renegotiated. And again, we don't know their salary history. We don't know their contracts. We don't know anything except she's asking you just to believe her as what I refer to as a professional expert.
Are you aware that Ms. Arnold's opined that but for the alleged defamatory statements by Mr. Waldman, Ms. Heard would have earned $45 million in the last 18 months and then the next 3 to 5 years?
Yes, I am.
I'd like to address some of the components of that one by one with you, Mr. Marks. Are you familiar with her testimony that Ms. Heard would continue to make films for approximately $4 million each following Aquaman 2?
Yes.
Do you agree with that testimony?
No.
Why not?
Well, again, in Aquaman 2, Amber Heard has already had this huge increase. She worked on Aquaman 2 for $2 million. What Ms. Arnold is saying is, oh, she should have worked on it for $4 million, which I disagree with. And I think there is reasons to negotiate. They weren't here in this case. So the $4 million I have a disagreement with. But even if it was at $4 million, or if it was at $2 million, the 4 or 5 movies that Ms. Heard might get might be independent movies. They might be standalone studio movies. They might be passion projects. Every actor has a quiver full of quotes, and their highest quote is for the superhero fantasy journey. Their lowest quote might be for the independent passion project, where they'll defer their salary and almost take nothing to work, just SAG minimum. And to assume that she'd get 4 or 5 more movies at this, her last fantasy quote, would be to assume that those are also those type of movies, playing another character. And Ms. Arnold says that Ms. Heard's breakout moment, her Star is Born moment, is Christmas 2018. If that's true, and I don't think it's true, those moments don't normally happen to supporting cast. But if it's true, as a deal maker, you would expect, if you represented producers, production companies, to flock in, to take advantage of this hot star and to sign them up. And we have, from Christmas 2018 to spring 20, where there is none of this activity. The Star is Born phenomena didn't happen. Ms. Heard starred in one series of 8 episodes, and she earned a healthy fee, $200,000 an episode. But that's 5 times less than the million Miss Arnold is tossing out, supposedly based on Jason Momoa's quote. She doesn't prove it or give us facts. And Jason Momoa is not a comparable actor. He's been in a series where they shot 78 episodes, 44 episodes, 21 episodes. He played Conan the Barbarian. He was in Game of Thrones. It's not a comparable.
I'm responsive to.
All right, I'll sustain the objection. Next question.
Mr. Marks, we'll get to some of those issues in a moment, but I want to take you back for a second. I believe you testified a few minutes ago that your understanding is that the last option in a multi-picture deal might be renegotiated under some circumstances. Do you have an understanding of whether Aquaman 2 was the last option in Ms. Heard's contract with Warner Brothers?
Oh, no. Aquaman 2 has not even been released, and Warner Brothers has a 4th option for Aquaman 3 or another movie where Mira appears, that character, and they've agreed to double the salary again. So it's in success, and that assumes that they recast and that they make the movie.
Are you aware of Ms. Arnold's testimony that Ms. Heard would have made several $1 million on endorsement deals, such as the one she had with L'Oreal?
I'm aware of that testimony.
Do you agree with that opinion?
No.
Why not?
Again, this is a business of personalities. We didn't, after the breakout moment that Ms. Arnold talked about, Christmas 2018, we didn't see endorsement deals flocking to Ms. Heard during that 16-month period before Adam Waldman made a few statements in the London Daily Mail, I believe it was. We didn't see those endorsements coming to her. We didn't, what Ms. Arnold shows you is these non-comparable actors, they had endorsement deals. But she doesn't show you, when she describes the breakout moment and why she's comparing Amber Heard to these, what I call uncomparable actors, but she's making the comparison. She's saying, well, they had all these deals, why wouldn't she? But for the statements that happened 16 months later, and I guess my primary question is what happened in the 16 months, even if you believe 3 statements in the Daily Mail are the stake through the heart of this Stars Born moment.
Do you have an opinion about Ms.
Boom.
Arnold's testimony that Ms. Heard would have made $1 million an episode and a couple of streaming series following her A Star is Born moment?
Yes, I heard it. I have an
And-
opinion.
What's your opinion?
Well, after Aquaman 1, this is a major coup. Amber Heard got that role. She tested for it. She could have been the other 19 actresses or 10 or whoever else tested, didn't get it. She got the role, and she got her salary doubled for Aquaman 1 to $1 million. Now, Ms. Arnold wants you to believe that that $1 million would translate into, she'd get that for each episode of a series. We know what she got for a series. She got a series in that period after Christmas 2018, before spring of 2020. She got a series. It was 8 episodes, and it was $200,000 an episode. And Miss Arnold is from somewhere
Yes.
in a glib way saying she got a couple series and $1 million each. And I can tell you, as someone in the trenches, rarely does an actor get $1 million for a series episode. And again, in those 16 months, there were no offers for series at $1 million an episode. In fact, her only series is the 200,000. And if you look at her resume, the series that Miss Heard were in, I think the longest one ran 8 episodes. Jason Momoa, if you were to believe Miss Arnold, and somehow Jason Momoa's agent broke their confidentiality in the agreement, and he had a series at $1 million an episode. If you're to believe that, Jason Momoa has had a series with 78 episodes, with 44 episodes, with 21 episodes, with 18 episodes, with 21 episodes. He was in, again, there's not a comparableness there.
It's
We spoke a few
a
minutes ago
different
about the
league,
best
but
option
bum.
agreement. What's the significance of the option part of that agreement?
The option part of the agreement gives the employer, the studio, the option. They don't have to do anything. They have an option to either employ you at a very healthy salary to play this role or not. They can recast the superhero role. You just have to think of how many actors have played Batman or Superman. They can do what they want. And indeed, since there's no contract, they only have a choice to exercise their option or not. They might say, we're not exercising unless you reduce your compensation. Who knows what the negotiation would be, but it's not a contract until the studio exercises the option, and they don't have to.
What's the alternative to an option agreement?
Well, the alternative is most agreements in Hollywood, you're hired to play the role. Or once you exercise the option, then it becomes, for that picture, an agreement like others in Hollywood. You are now hired to play that role. So most contracts are guaranteed. You're hired to play the role. In an option agreement, once they exercise the option for that movie, it becomes a guaranteed contract.
Are you aware that Ms. Arnold testified that Ms. Heard was released from her Aquaman 2 contract and then subsequently?
If she has people like that advising her, no
Heard that
wonder
testimony.
she's lives in the
Is that consistent with
disappointments
your
room.
Experience of the film industry in connection with these multi-option contracts?
No.
Why not?
Again, studios don't do things they don't have to do. As we heard Mr. Hamada, the president of the studio, say, you either exercise your option or you don't. They exercise their option. He denied releasing and then rehiring. And in my experience, in almost 5 decades in the business, doing this type of work, not talking about it, not consulting. I mean, I have, I heard Miss Arnold say she'd been an expert 100 times. I'm a transactional lawyer. I do this occasionally. Basically, you know, it's not a contract till they option it, and they pick up their option, and at that point, it's guaranteed contract, and then different rules apply to it.
In your experience in the industry, do studios typically comment on those types of actions that they're taking with respect to options?
No, just like Mr. Hamada said, they don't need to comment on it. They either exercise the option or they don't. In Hollywood, silence is the default. You play no card before it's time. And the cards there were exercise the option or not. And I was surprised by Mr. Hamada under oath, basically saying that there was this discussion of chemistry. That
Objection, Your Honor, hearsay.
I think it was an in-court statement this morning, I believe, Your Honor. That's fine.
It's the same hearsay that you were, it's hearsay like yesterday. I mean, it's hearsay.
I'll overrule the objection. Go ahead.
Thank you.
I didn't hear.
Go ahead, sir.
Overruled. You can continue, Mr.
Oh,
Morrison.
I was surprised to hear Mr. Hamada say that they talked about chemistry. That would normally be behind closed doors because you can't help.
I think he only
relationship.
said it because it was
There-
asked.
You're either going to exercise or not, and that was quite a bit of candor from someone at his level. And so, therefore, I take it at face value. I think he felt that he was under oath and he was telling the truth, but it wouldn't
Objection,
be.
Your Honor, is
I'll sustain the objection.
Mr. Marks, are there circumstances where a studio would be more likely to say something about not using an actor again in a franchise?
Yes.
What are those circumstances?
Once they've exercised the option, once the contract is guaranteed, the studio still has the right to pay the actor, but not pay or play them. And that is a rare condition because you've hired the actor, you've got to pay them, but you say, go home, we're recasting. In that situation, after you've exercised the option and the contract is guaranteed, if you pay off the actor, that's normally commented on. That becomes a bit of information because it's not normal.
Is that circumstance different from Ms. Heard's contract with Warner Brothers for the Aquaman movies?
Oh, yeah. Ms. Heard's contract, again, it was just an option. Either we exercise it or we don't. And if we exercise it, she's in the film. If we don't.
Oh, she's
not.
back on the Post-it notes, y'all.
Until we exercise it, we have our right to recast or not make the movie. And even after we exercise it, we'd still have a right to recast and not make the movie. We just have to pay her salary.
Do you understand that Ms. Arnold compares Ms. Heard's career trajectory with that of other actors, including Jason Momoa, Gal Gadot, Zendaya, Ana de Armas, and Chris Pine?
I heard that.
What's your opinion of those actors as comparables for Ms. Heard?
I'm sorry.
Even Ms. Heard's agent, Jessica Kay, said that four of those actors weren't
objection, Your Honor,
comparable.
hearsay.
I believe same response, Your Honor, that it was in testimony that was played in court earlier this week.
I mean, that's not what she testified to. I mean, he's characterizing testimony that was from days ago, and I don't even think she testified to that, Your Honor.
But you can cross-examine.
Overruled. You may continue, Mr. Rose.
Again, they are not comparable. Jason Momoa was Aquaman. Chris Pine was Captain Kirk. Gal Gadot was Wonder Woman. Zendaya has been working on Disney Channel since she was 13. She's in all the Spider-Man movies. She goes by one name. Ana de Armas, when she was in a movie that they call, her break breakout. It was as a nude poster. She's been an ensemble piece, Knives Out. These are not comparables. Now, Miss Arnold stuck to Jason Momoa, who's the most non-comparable because of his history and his career. But she didn't give us the advantage of telling us what his contracts were, what he renegotiated to, what he earned. She didn't give us any of those building blocks. She set him up as a comparable and then said what Ms. Heard should earn, but she never gave us the salary of Jason Momoa or the other comparables. And she built like this house of cards on nothing.
Tell it.
She showed us with her words, the beautiful clothing that the emperor was wearing. But we could see, if you know the business,
Objection, Your Honor.
that he
Go
wasn't.
beyond the scope of the question.
All right, I'll sustain the objection. Next question.
Okay. You were just speaking about Mr. Momoa as a comparable. Are you aware that Ms. Arnold compares Ms. Heard to Mr. Momoa as an actor with equivalent franchise experience who was able to renegotiate his salary for significant increases in bonus?
Yes.
What's your response to that opinion?
Again, he didn't have comparable franchise experience to Miss Heard. He was Conan the Barbarian. He played Aquaman in a movie that Amber Heard was not in. He played Aquaman, not a supporting character like Mira. It's just not comparable. And you can say the words, but I saw nothing from Miss Arnold to back it up, something to build on, which if she was a negotiator in the trench,
Hey,
the
nonstop
studio
mom.
negotiator would say, okay, so show us, where's the comps? First, because ultimately that's where we have to get to, not just because you say it so. We just don't believe you. You've got to show us.
In your experience in the industry, what factors influence the negotiation of the terms of a film agreement with an actor?
Well, I mean, first, it depends on the film. If the film is $1 million movie and everybody's deferring their salaries, that's one thing. If it's a superhero movie, that's another. But for deal makers and negotiators, the best predictor of is past earnings.
So he is an entertainment attorney. He negotiates the deals. He has actual working knowledge of how contracts between the actors and the studios work, because he does this. This is his job. He doesn't testify. He's not called as an expert witness in court as the other person was.
Ms. Arnold talked about past earnings at all, except the earnings in this rarefied superhero 4-picture deal, where instead of incremental increases, which you normally see.
Good morning, anaphylaxis.
It was multiples increases. And then when you get on a series, the big renegotiation was when the network has no more options. Until then, the actors on the series get 5, 10, 15 small percentage raises. They don't get multiples. They get the multiples if it's a success and the studio wants to continue making the series and they want to keep these characters. That's when the renegotiation happens. Here, even if we believe Ms. Arnold, after Aquaman 2, there was still an option waiting at a big price, double the previous payday.
What's the significance of the timing of the Waldman statements to the opportunities Ms. Arnold claims Ms. Heard lost?
Well, the argument, as I understand it, is that Ms. Arnold says that Ms. Heard lost all these opportunities because of those losses were caused by Adam Waldman's statements 16 months later. So I think the timing.
Sure.
Pretty much. So, um, I wish I could, babe, but I can't. I have no control over that. If I did, I would for you. Yes, I would. Basically, yes. Nonstop mom. They're basically her witness that testified yesterday. It was claiming that Amber Heard is comparable as a star to Jason Momoa. And what this gentleman has pointed out is even if she were comparable as an actor to Jason Momoa, what that witness failed to do was set up the
Mr. Marks, what's your overall assessment of Ms.
proof
Arnold's opinions in this case?
that Jason
My
Momoa
overall assessment of her opinions is that they're
renegotiated
not
his
worth the paper
contract
they're not written on. She
to
knows
what she
something about our
claims
business,
would be
but
would
not
be the
about
potential.
negotiating deals.
That's the problem.
She may have gotten someone at the Endeavor office to breach confidentiality, but she never
Objection,
laid
Your Honor.
out
It's now going beyond the scope.
the building
Objection.
blocks.
Excuse me, there's
Objection.
objection. You have to stop talking, Mr. Marks. Thank you. Beyond the scope.
Yeah, Mr. Marks, can you just limit your testimony to your opinion about
Okay.
Ms. Arnold's opinions, please?
My opinion, as someone who's made deals as a deal maker for almost 50 years, is that she calls herself an expert, but she's not. She doesn't have the background. She doesn't have the day-to-day knowledge. And her testimony that I heard did not back up her bottom line. If you want to get those figures, you have to show why they're deserved. And again, she was constructing a Jenga without the bottom pieces. It does not hold up under scrutiny by someone who makes deals.
No further questions.
All right, cross-examination.
Good morning, Mr. Marks.
Good morning.
So you agree that studios use comps to negotiate deals, correct, with actors?
Sometimes they do.
And you have an issue with the comps that Ms. Arnold used, correct? As you testified to.
I have an issue with the comps that she says she used that she didn't disclose.
The comps being the actors that you just talked about. She did disclose, she disclosed the actors.
She disclosed the actors and budget figures from their movies. She never disclosed their salaries and salary history as comps.
You're not offering a different set of comparators that should be used, correct?
I'm saying if you are going to.
That's not my question. Are you offering a different set of comparators than what Ms. Arnold used?
I'm not here offering comparators. I'm saying what she offered are not comparators.
That was my question. You're not offering comparators, correct?
No, I would say that Ms.
That was
Heard's
my
comparisons are where you
That
look.
was my question. Motion to strike after the.
All right, we'll strike after that. Just answer the questions, Mr. Marks. Thank you.
Now, you're a deal maker, correct?
Yes.
What actors have you negotiated for in superhero movies?
Well, recently I've negotiated for Chris Pratt in a superhero series for Amazon. I've negotiated a deal for Michael Douglas, not in a superhero movie, but a historical movie. I've negotiated recently a deal for Paul Rudd and Will Ferrell on an Apple series. Billy Crudup on an Apple series. Those are the recent talent deals.
What actors have you negotiated for in a superhero movie?
As I sit here now, I can't remember a superhero movie that I've negotiated. I've certainly negotiated over my career franchise movies and fantasy movies.
Your Honor. So it's no, you haven't negotiated with for any actors for superhero movies, correct?
So you would define like, I don't know, Jungle Book isn't a superhero movie. It's more of a fantasy.
Okay, so no, correct. Your answer
Okay,
is no.
all right. So as I sit here, I can't think of a Marvel type superhero movie that I've negotiated. Although I know there's one or two in there.
Now, you testified and you agree that Mr. Momoa negotiated his multi-picture contract for Aquaman 2, correct?
I heard Mr. Hamada say there was a renegotiation, but no facts were proffered, such as he didn't have an option. His options were out, what he was earning and what he renegotiated to, and he is Aquaman man. So yes, I did hear there was a renegotiation.
And you understand that his salary went from $3 to $4 million to $15 million.
If you tell me that, I haven't seen his contract and I haven't heard any. Yes, $4 million.
Would you agree that the money Amber was making on Aquaman 2 or 3 would be her market rate for future studio movies?
I would think it would be her rate for future studio superhero movies, but not necessarily studio movies that aren't superheroes. That could be standalone. That could be other type of studio movies.
But for studio superhero movies, it would be $4 million, correct?
If I was Ms. Heard's agent, that's where I would start. Assuming everything was equal, the budget of the superhero movie, that she was in the ensemble. There's a lot of ifs to look at, but all things being equal.
You agree that Aquaman was a breakthrough role for Ms. Heard, wasn't it?
It's the first movie of that ilk that she makes, but she is not Aquaman. She is Mira.
But it was a breakthrough movie for Ms. Heard, correct?
For her, it's a breakthrough movie to be in that film and in the ensemble. Absolutely.
And she was the female star of that movie, correct?
I believe so.
You would agree that for all of the actors Ms. Arnold listed as comparables, their career trajectory went up after their breakthrough, correct?
She didn't give us the raw materials to look at, but I'll take your word that all those unrelated actors in unrelated films, except for Jason Momoa, they went up. As did Miss Arnold's when she went from 1 to 2.
In your experience, can you identify an actor or an actress who's not been able to get a new studio movie after a breakthrough performance in a superhero movie?
As I sit here now, I haven't been asked to opine on that, but there are lots of supporting characters in movies that don't appear in the next movie.
But a female star in a breakthrough movie, in a superhero movie, can you identify any actress who's not gotten another studio movie after that?
Well, after Miss Heard's breakthrough in 2018, she did get Aquaman 2.
Aquaman 2 was already, she already had the option for Aquaman 2,
all right.
correct?
So she did, Miss Heard did not get any movies after 2018, long before the Adam Waldman statements.
Other than Miss Heard, can you identify any actor or actress who's not gotten another studio movie after their breakthrough in a superhero movie?
As I sit here now, I haven't been asked to research that, and I can't. That would be a normal thing.
And you're not providing an alternative number for Miss Heard's damages, correct?
I can.
For the jury.
Correct. I'm not providing an alternate number. I think, she's been more than adequately paid.
I'd move to strike after. No, I've not been providing another number. That's all. I mean, my question was, you're not providing another number.
I think it's in fairness and the full answer to the question, Your Honor.
It was a yes or no question. He said his answer was no.
I'm not going to strike it.
Okay.
But let me just make sure. Let me check my notes because I feel like I have the answer, but I want to just verify. Okay. So give me just 1 second and I will.
Mr. Marks, in response to some questions from Mr. Nadehoff, you were discussing some franchise and fantasy movie agreements that you've negotiated with actors. Could you just describe some of those for us?
I've had such a long career that I mainly forget what I've done, but I negotiated all the contracts for Pinocchio, if you will, that was produced,
The answer to that question is Helen Slater, who played
is
Supergirl
Coming
in
to America,
1984,
the original,
and then The
is
Legend
that
of
a
Billie
fantasy
Jean in
movie? The Golden
1985,
Child,
and
is
then
that a
Fairly
fantasy
Well
movie?
fizzled out.
Yeah, and by the way, I may have negotiated contracts, and ultimately the film wasn't made. But as I sit here now, those are the only ones that come to pass. If I was looking at my resume or going through my files, I might think of others, but there isn't a deal that I haven't made.
And I think you also testified in response to Mr. Nadelhoff's questions that you have negotiated some deals for.
Hey, Shalima,
Chris
good to
Pratt
see
and
you.
Paul Rudd. Do you recall that testimony?
Yes, these are for a streaming series.
Do you happen to know if both of those actors have played Marvel superheroes?
I believe they have,
Cement
but don't
shoes.
quote me because, that's not my genre.
No further questions, Your Honor. All right. Thank you, Mr. Marks. You can, you're free to stay in the courtroom or you can
Okay,
leave.
so you guys,
Thank you very
I
much. Thank you.
Googled, is Mira
Your
a
next
member of the
witness.
Justice League? And while we wait for this next witness to call, let me tell you what Wikipedia has. In recent years, Mira has featured as a member of DC Comics' flagship superhero team, the Justice League. Queen Mira's storylines have also portrayed a mental breakdown faced with crippling loss and explored her attempts at coping with lasting anger and rage. Now, that sounds right
Good morning, Mr.
up
Spindler.
Amber Heard's alley, and yet fail.
Very who you are and what you do.
Yes, I'm Michael Spindler. I'm a forensic accountant. I'm a CPA, a certified fraud examiner, amongst some other certifications. I'm with B. Riley Advisory Services, a national firm that does forensic accounting, bankruptcy and restructuring work, and business valuations and appraisals. I've got over 40 years of experience.
Are you familiar with the testimony rendered by Ms. Arnold in this matter?
Yes, I am.
Just so you know,
You
your
understand
girl's
when Ms.
always
Arnold
looking out for
testified
y'all,
that Ms.
bringing you
Heard
the
suffered
faxes.
Economic damages resulting from 3 statements made by Mr. Walt.
Yes, I do.
Do you have an opinion of that claim?
I do.
All right.
Why are we objecting? For pity's sake. As I sit here today, I can't think of a more apropos and well-suited role to Amber Heard than Mira. And yet, no chemistry. Interessante. Just so you know. And also, I'd like to remind you that my research and investigation will continue. I will be watching both versions of the Justice League. I will be paying attention to the amount of screen time that Amber Heard receives. And I will be bringing that to you. I don't know if I can do it. I probably can do Justice League tonight, the first one, because that one's only 2 hours, and I can tell you how much screen time she gets. And then tomorrow, I can do, Zack Snyder's Justice League and let you guys know, because that's a longer movie.
Thanks, Mr. Spindler.
And I want to go
Now,
live
you
tonight too, to
indicated
hang
that
with
you
Chow.
would listen to Ms. Arnold, and she testified on behalf of Ms. Heard relative to economic damages. Have you formed an opinion as to the testimony and opinion rendered by Ms. Arnold?
Yes, I have.
What's that opinion?
It is not adequately supported and it is unreasonable.
There were multiple elements to that analysis, both damages related to her film career and to endorsements. Have you analyzed both those issues?
Yes, I have.
What is your opinion of the claims that have been asserted relative to the film?
Thank you, Chick Tracy. I appreciate your appreciation.
Okay, well, first of all, with respect to her damages calculation, there was no calculation per se. She initially
That's right. Break
looked
it down,
at
Mr.
these
Spindler.
comparable actors and seemed to use that as a basis for numbers. She didn't provide the underlying calculation. She didn't provide underlying support. And then it appeared as though in her testimony, she backed away a little bit from that, but she still suffers from the issues of not providing detailed calculations or support for where those numbers come from. And she still, to some extent, appears to be using some kind of comparable analysis.
All right. What is the type of analysis that you think is appropriate here?
Well, I think, and as you heard from the last witness, I think that something that is anchored in facts, taking a look at historical compensation as a basis for anticipating future compensation.
Had you looked at Ms. Heard's
Thank
prior
you, Chick
compensation?
Tracy. And no,
Yes,
your
I
name
have.
show ain't Amber.
I've looked at tax returns that were provided for the period of 2013 through 2019.
Why do you want to use historical earnings?
But once again, you want analysis is anchored in fact. I don't believe that Ms. Arnold has done that in her analysis. So here we've got some actual data, we've got some historical compensation, and as the last witness mentioned, that often provides somewhat of a basis for future anticipated earnings. In addition, I believe that Ms. Arnold herself said that she had hoped to be able to look at a renegotiated salary for Aquaman 2 and then use that as a basis for future compensation, that being the new kind of base, if you will.
All right. Were there any years in particular that you focused on in your analysis as to Ms. Arnold's testimony?
In terms of the historical compensation?
Yes.
Well, for 2013 through 2019 in total, her compensation was around $10 million for all those years combined. In 2019, the last of those years, her compensation was somewhere between about $2.6 million and $3 million. Now, that's a good year. That's known as a clean year.
What do you mean by a clean year?
Well, for example, 2019, you had Aquaman was released in December of 2018, and that was a successful film. So in 2019, you've got the benefit of that kind of success, and you also don't have any potential impact from the alleged defamatory Waldman statements
Pretty
that
much.
occurred in April of 2020. So 2019 is clean of all of that.
What did you understand Ms. Arnold's methodology to be?
Her methodology initially appeared to be based on these comparable actors that she had identified, and theoretically, the compensation that they earned, although she doesn't identify what that compensation is or provide any support for it or any calculations.
Yeah,
What
homeboy
is
here
your
does the
opinion of that
maths.
methodology from an accounting perspective?
That methodology was unsound. It's just unsupported. There are no numbers. There's no data that she provided and support for that.
Boom.
What methodology did you understand Ms. Arnold to adopt at trial?
Okay, well, it looked like somewhat of a mix and match approach. She used different approaches, I believe, for different elements of the damages, although it's still a little bit unclear to me, a little bit vague. But there are 4 basic components that she was looking at, and we can go through those in any order you wish.
All right. With respect to the television series portion of her analysis, what do you understand that methodology to be?
Okay.
Objection, Your Honor. May we approach?
Oh, for Pete's sake, Rottenborn. Now, I will say that I am pleased that that their rebuttal witnesses have started off in this manner, because remember, we all talked about this, and it was my opinion days ago, a week ago, whenever the hell I said it, I don't remember, to be quite honest with you, but I know I did say it, that what was necessary in this situation and under these circumstances was for the rebuttal to center around the core issue, which is the op-ed and the finances surrounding it. Who lost money because of the op-ed? Who didn't lose money? Then with respect to Miss Heard's counterclaim, again, the same thing. Who lost money, who earned money, etc., because that is really what the jury, when they go back in their deliberations, that's what they're really going to be deciding. Obviously, they're going to be deciding if there was abuse, and if physical violence, and if so, who was the victim, who was the perpetrator. And so that's going to go to the portion of the defamation that would be the what's the word, the lie, which is not that word, it starts with an M and it's on the tip of my tongue. Malice, malicious intent, which is the lie. So it's that's, I'm glad to see that Johnny Depp's team is using their time in this manner, because this is very, very important. This is really what the whole lawsuit is about. Who lied, who's telling the truth, and whose career and finances were affected. That's what it's about. And I think it's important for them to put on these types of witnesses. No, I didn't hear that. I've learned a lot. It's interesting. So it's very important, I think, for Johnny Depp's team to put these witnesses on and offer them as experts. And the way that the questioning is going, I like it, because it's interesting and it's fact based. And it's one thing to give testimony to a jury, right? But when you have an expert witness, it's very, very important for the expert witness to explain to the jury how they arrived at their conclusions. And I feel that thus far, he's doing an excellent job. I'm able to follow. And I'm relatively good at math. I'm not good at geometry. I'm not even going to front. I failed geometry the first or the second semester. I barely passed the first. I had to take it in
Earnings
summer
from
school.
television shows. Did you analyze what historical earning Ms. Heard had during the period that you were concerned with relative to television shows?
Well, yes, during 2019, she entered into a contract in July of 2019 to appear in a television series at $200,000 per episode.
All right. What about endorsement deals? Did you look at what she had made on endorsement deals during that period?
She did have a contract with L'Oreal at $1,625,000.
All right. With respect to her movie roles, what were her historical earnings during that period?
Well, certainly for the most recent years, you had the Warner Brothers deal, which was a 4-picture deal. The first film was $450,000.
I'll go and check it out. I've learned a
Then the
lot. Thank
first
you.
Aquaman was $1 million base fee. Then $2 million for Aquaman 2. And presuming that there was an Aquaman 3, that would have been $4 million.
Okay. Why do you look at historical earnings as part of your analysis?
Because you want your analysis to be anchored in facts. You want it to have a sound methodology, and you want to come up with a reasonable result. So if you take a look at, for example, the analysis that Ms. Arnold did, it didn't appear to be.
Let's just look at the analysis that you're doing.
I don't
what you said,
badmouth geometry. I just don't
you want it
understand it.
Anchored in facts. Why?
Because that provides a sound basis for coming up with something with reasonable certainty. There's AICPA or American Institute of Certified Public Accountant guidance with respect to reasonable certainty. And those are the basic elements of it.
Thank you. No further questions.
All right, cross-examination.
Also, Johnny Depp's team is using their time wisely and effectively. They're not belaboring the point. They're getting in, making the point, and getting out.
I'm going to ask you a few questions that may refer to the statements in Amber's counterclaim against Mr. Depp. When I refer to those statements, I'm going to refer to them as the Depp-Waldman statements. Do you agree that we can both be on the same page what I'm referring to when I say that?
That's fine. You can use your terminology.
I'm sorry, there's objections.
I knew there was going to be. You can't listen, Mr. Rottenborn. There should be an objection, because the truth of the matter is it is now, after today's ruling, for sure. Hey, not your mama. Babe, you got to, girl. I'm glad you just got a ticket. Okay. There should absolutely be an objection, because after today's ruling specifically, the judge has declared in effect that the jury is going to be the ones who decide if the statements made by Adam Waldman can be attributed to Mr. Depp and in relation to his liability for said statement. So
Mr.
to
Spindler,
call
when I refer
them
to the
that
Depp-Waldman statements, you
is
understand that
baloney.
You're referring to the statements in Ms. Hurd's counterclaim against Mr. Depp, correct?
I'll understand that, yes.
Now, you're here to provide a rebuttal opinion to Ms. Arnold's part of Ms. Arnold's testimony, correct?
Correct.
You're not providing an opinion on whether Ms. Hurd suffered defamation by Mr. Depp, correct?
That is true.
You're not offering an opinion as to what any of the underlying facts relating to whether Mr. Depp abused Amber, correct?
That's correct.
You're not offering an opinion as to the magnitude of damages that you believe Ms. Hurd may be entitled to if she proves defamation by Mr. Depp. You're just reviewing what Ms. Arnold has said, correct?
That's correct.
And you said that you want your analysis to be accurate in the facts, right?
Anchored in facts.
Anchored in facts. You'd agree that what an actor earns in one period isn't necessarily reflective of what he or she may earn in future periods, correct?
Correct.
And that's because
there can be some
increase in the
variability.
number of roles,
Yes.
an increase in the number of roles may lead to greater income, correct?
I'm sorry. Could you repeat that? I was speaking. I didn't hear.
One of the reasons that what you earn in one period may not be reflective of what an actress may earn in future periods is because an increase in the number of roles may lead to greater income, correct?
The number of roles or the particular project itself, yes.
Sure, getting better roles may lead to greater income, correct?
Correct.
And the same is true for an endorsement. As an actress's profile grows, the amount of money that she may be able to earn from endorsements grows as well, correct?
It can.
So
it depends.
What Ms. Hurd earned from, say, 2013 to 2019 that you testified to isn't necessarily reflective of what she might earn over the next 5 years, correct?
Not necessarily. It is a good indicator, though.
And you'd agree that from
Which is all he's
2013 to
saying. It's a good place
2019,
to
in terms of
start.
earnings and star power, that Ms. Heard's career trajectory was on the upswing, correct?
There was a slight increase during that period of time in her earnings from 2013 through 2019.
And you'd agree that that was as a result of getting more lucrative roles, right?
Yes,
Now, you're not a causation expert, right? You're just a damages expert.
that's correct.
So you're not testifying as to whether the Depp-Waldman statements caused her to lose any roles, correct?
That's correct.
And you're not offering any opinion as to whether the Depp-Waldman statements kept her from being considered for roles that she otherwise would have been considered for, correct?
That's correct. I'm not testifying on causation issues.
And you can't speak to what opportunities may never have materialized for Amber as a result of the Depp-Waldman statements, correct?
Yeah, I've not done those calculations.
And you don't have an opinion about whether or not Ms. Heard could have renegotiated a contract for Aquaman 2, correct?
That was not part of my work.
And you don't have an opinion on the impact that additional exposure or press coverage or magazine covers or interviews would have had on Ms. Heard's career, correct?
Correct. I'm just looking at Ms. Arnold's calculations.
Well, she's got tons
You've
of
never served
exposure
as an
right
expert
now.
witness before to calculate
How's it going
damages
for
based
her?
on lost roles by an actress resulting from defamation against that person, correct?
I've been involved in defamation cases, but I've not done the calculations as an expert witness and testified thereto.
And there's never been an instance in which you have served as an expert witness in a case to calculate damages based on alleged defamation against an actress, correct?
Correct.
And you're not offering any expert opinion on what impact the alleged defamation by Mr. Depp has had on Ms. Heard's career, correct?
I'm sorry, one more time?
You're not offering any expert opinion on what impact the Depp-Waldman statements by Mr. Depp has had on Ms. Heard's career, correct?
Other than taking a look at Ms. Arnold's calculations.
And you're not offering any expert opinion about what impact, if any, social media coverage of this case or of Ms. Heard may have had on Ms. Heard's career, correct?
You're correct. That's other experts.
Can we approach
No
her?
further questions. Thank you.
All right.
I mean, look, here's the deal. Okay. Truth be told, there's almost no bad press, right? Her name is out there.
Okay.
All right, thank you, Mr. Spindler. You can
Thank
have a
you.
seat in the courtroom, or
Thank you,
you are free to
everyone.
go. Thank you.
But
All
frankly,
right, your next witness.
Plaintiff calls Doug Banya, Your Honor.
I think they're failing
So last name?
to
Bania.
connect the dots here that she lost income because of the Waldman statements, because she wasn't earning anything prior. You know what I'm saying? Like, she wasn't being offered new roles during that time period prior to him making the statements. So I don't see how she is equating. It's not like she had a role offered to her, right? And they were negotiating it out, and the Waldman statements came out, and she lost the role. That's my point.
So just a reminder that you're still under oath, okay, sir? Thank you.
But they're making excellent use of their time. I'm
Good
very
afternoon, Mr.
impressed.
Banya.
Good afternoon.
Can you briefly reintroduce yourself to the jury?
Yes, please, because I don't know who you are.
Doug Banya. I am from Nevium Intellectual Property Consultants based in San Diego. I value intellectual property. I provide litigation support in infringement and defamation cases, as I'm doing today. And I use internet and social media analytics and both of those services.
Since you last testified in this case, the jury has heard testimony from Ronald Schnell and Catherine Arnold. Are you familiar with their testimony?
Yes,
Were you asked to analyze their testimony and provide opinions in response?
yes, I was.
Have you formed opinions in response to the testimony of Mr. Schnell and Ms. Arnold?
I have.
Generally, what are those opinions?
Generally, Mr. Schnell provided no evidence of a correlation between the Waldman statements
and the hashtags and the spikes of those hashtags on Twitter. Second, based on my internet and social media analytics investigation, I've concluded that the alleged comparable actors that Miss Arnold came up with are not comparable with Miss Heard. And then thirdly, Mr. Schnell and Miss Arnold both failed to provide any evidence of a causation as it relates to the Waldman statements causing any economic harm to Miss Heard.
Let's dig into those opinions a little bit. You're familiar with the testimony of Mr. Schnell that there
Yes,
are more
let's.
than 2.7 million alleged negative tweets related to Ms. Heard between January 2018 and June 2021?
Yes.
And what's your understanding of how Mr. Schnell identified those particular 2.7 million tweets?
Yeah, so essentially Mr. Schnell chose hashtags that he felt were negative towards Miss Heard. Those hashtags range from justice for Johnny Depp, Amber Heard is an abuser, Amber Turd, and the hashtag, we just don't like you, Amber. So then he used those hashtags and he searched through, using the Twitter API, searched through various tweets and then came up with any tweets that were using those hashtags.
I'm sorry, having an expert
conduct
witness
an analysis
testify
of
and
those
use the
tweets?
term Amber Turd is
Yes,
never
I
going to
was
not be
given
funny
that
to me.
exact,
Sorry.
the data that Mr. Schnell used on a hard drive. So yes, I dug into that data as well.
And what was the purpose of your analysis?
So what I'm trying to do, and what's at issue of the case today at this point is,
I'm going to put you in charge of that, Amelia.
Did they contain the Waldman statements? That's what where we're at right now, are the Waldman statements. So I wanted to analyze those tweets to determine which ones, and if any, contain the Waldman statements.
And what's your understanding of what the Waldman statements are?
So my understanding is there's three Waldman statements that were published in the Daily Mail. The Daily Mail is a UK tabloid, and Mr. Arnold was quoted in three of those articles. And those dates were on April 8th, 2020, April 27th, 2020, and on June 24th, 2020. And my understanding that those quotes, sorry, I think I said the wrong name, but those quotes are the only remaining in this case.
Did you analyze the timing of the tweets that we were talking about as compared to the timing of the Waldman statements?
And that's exactly what I did. So I wanted to look at the Waldman statements, look at the dates that they happened, and then analyze those as compared to the Twitter data that I had.
Have you prepared a demonstrative that reflects that aspect?
Oh,
of your
please
analysis?
show
Yes.
us a demonstrative.
Your Honor,
Oh,
may
I'm
I
so
approach?
happy.
Yes.
Please to hold. I'm just going to mute
Show counsel.
just briefly because I want to enjoy this with you, but be quiet while I do it as to not take away from your enjoyment of a demonstrative. I love a demonstrative.
All right, so 1293 will just be marked for identification as demonstrative and can be published to the jury.
Mr. Vina, can you explain to the jury what this demonstrative shows?
Yes. So this shows the total hashtags and tweets that Mr. Schnell was analyzing. This is the summary data. There are tweets that are running from January 2018 to June of 2021. And again, these are related to the four hashtags that I discussed. Whenever I get an assignment such as this, when I'm dealing with a defamatory statement that's allegedly gone viral online, where there's economic damages involved and there's a lot of data involved, I like to take the data and I like to do a 30,000-foot view of the data to see what I'm looking at, to see if there's anything interesting, odd, different about the data. And the first thing that I noticed is 35% of the tweets were prior to the Waldman statements. So again, remember, my assignment is to determine if the Waldman statements are part of the tweets that Mr. Schnell analyzed. So obviously, if these tweets were prior to the Waldman statements, in no way could they have anything to do with the Waldman statements. So that was the first issue that I noticed. Then I noticed what I like to call kind of the alleged defamatory time frame. And as I discussed, that's when the Waldman statements were published. That's the date down here. You know, the first one was in the beginning of April, and the last one, which is the third one, was at the end of June. But what I found interesting is only 2% of all of the tweets happened during this Waldman statement period. So really, these are just observations. And for me, there were red flags that I made note of, and then I just continued with my analysis.
What other work have you performed in connection with forming your opinions about the purportedly negative tweets?
Yeah, so now I realize that 35% are irrelevant and 2%, only happened during this important period. I just continued to dig into the 2.79 million tweets that Mr. Schnell provided.
And Tom, can we take that one down? And Mr. Banya, have you prepared another demonstrative that depicts that analysis that you were just describing?
Yes.
Your Honor, may I?
Okay, yes. Okay, we'll just see if he has an objection. No, I'll give you time to look at it, sir. All right, plaintiffs, you can turn on your microphone, I'm sorry.
No objection as a demonstrative.
Okay, all right, plaintiffs exhibit 1294 will be marked for identification as a demonstrative and will be published to the jury.
Thank you, Your Honor. Mr. Banya, can you explain what this demonstrative shows?
Yes, this is showing the various spikes as it relates to the hashtags that Mr. Schnell testified about. This is actually an exhibit or a demonstrative that he used in his testimony. What this is showing are the largest spikes related to the hashtag Justice for Johnny Depp. I don't know if you remember his testimony or any of his demonstratives. The other three hashtags did spike at the same time, but a very small spike. So what I'm showing you here are the 6 top spikes in Mr. Schnell's analysis. And what's important here again is the very first spike and the largest spike again happened before the Waldman statements. So what I'm trying to figure out is what tweets were related to the Waldman statements. So this number 1 spike, which is the biggest spike, was prior to the Waldman statements. So it's irrelevant to the case. And then the second thing I noticed that was interesting here is here are the dates in gray right here. This is the time in which the Waldman statements happened. And you're going to notice, as we discussed before, only 2% of the tweets happened during that time. But I found it very interesting for such a viral event that has potentially caused such economic harm. There's no spikes in this area. And actually, you're going to see that Mr. Waldman, his statement came out here in the first April 2020 article. Then the second one came out here, and then the third one came out in June. There's actually a downward use of the spike, downward use of the hashtags. So I'm not seeing any correlation as it relates to the Waldman statements and any spikes here as it relates to the hashtags Mr. Schnell chose.
Did you analyze each of the spikes that are depicted here?
Yeah, so what I did is I looked at the 6 different spikes, and you're going to notice that each spike represents a month. So the second spike, is July of 2020, and so on to the 6th spike going to April 2021. And what I did is, I don't know if you remember my last testimony when I went into Google search, and I'm able to go into Google search. I went in and I typed in Amber Heard. And then after you hit search, you can use the tool and you can go back in time. And I chose each 6 of these dates to go back in time to see what was the media talking about back then. What was the general public being fed as it relates to Amber Heard back during those spikes. And what I found is none of them, well, actually I analyzed the top 3 search results because they represent 50 to 70% of what people click on. And I realized that none of them had anything to do with the Waldman statements.
Are you aware of Mr. Schnell's testimony that the tweets using the 4 hashtags he looked at were mathematically correlated?
Yes.
What does that mean?
So what Mr. Schnell is saying, which is irrelevant to this case, is the 4 hashtags that he randomly chose, they tend to go up and down together. And that's why he had these spikes here. So the correlation there is how those 4 hashtags work or dance together going up and down. But first of all, the hashtags have nothing to do with the Waldman statements. And the fact that there's a correlation with the hashtags is irrelevant to this case because we're dealing with the Waldman statements, which none of that correlation analysis he did had to do with.
How do you know that the correlation doesn't have anything to do with the Waldman statements?
Can I clear this at all? No. Oh, yeah. Well, first of all, I know because that would happen right here. If when Mr. Waldman, one of his quotes was published, you would see a big spike right here. And then you would see maybe a little noise down here. And then the third time you might see second time a big spike, and the third time a big spike. That's not here. So that's telling me there's no correlation between the Waldman statements and this hashtag use. And then I've actually provided evidence that
yes, they can. And that's the most important part.
And none of them had to do with the Waldman statements.
Is mathematical correlation the same as causation?
No.
Why not?
I mean, correlation is simply a relationship between 2 or more variables or 2 or more things. In this case, the correlation question is, when the Waldman statements were published, at the same time, did you see a correlation with spikes in these hashtags? And again, can we clear this? You see none of that right here. It's actually a downward trend. There's no spikes, there's no correlation. So, again, Mr. Schnell provided no evidence of any correlation.
What correlation opinion did he provide during his testimony?
Well, he provided the correlation that the 4 hashtags, spike together. But again, the hashtags have nothing to do with the Waldman statements, and the facts that they're correlating or moving together is irrelevant to the case because the case is about the Waldman statements.
So what is causation then?
So causation is where one thing causes a change in the other. So as it relates to this case, did the Waldman statements cause Ms. Heard to have economic harm? In other words, did the Waldman statements cause Ms. Heard not to make as much money in her career? And again, Mr. Schnell provided no evidence of this. Ms. Arnold provided no evidence of this. And as a matter of fact, during Ms. Arnold's testimony yesterday, she didn't even know what causation was. You know, she was asked, do you know the difference between causation and correlation? And she said that she's not a semantics expert. We're not talking about the words. You know, when it comes to damages, you have to prove causation prior to calculating damages. You know, so there is no causation that's proven here. Therefore, a damages analysis is not appropriate.
Did you hear Mr. Schnell testify that he agreed with your opinion in this case?
Yes.
And what's your understanding of the opinion that he agreed with?
Well, he agreed that he failed to link the spikes in the hashtags on Twitter to the Waldman statements.
Did he try to do that?
He tried to do that. But again, his analysis was looking at the word Waldman and looking at the word Waldmanian, and then trying to say that 25% of the tweets included those two terms. But first of all, Waldman isn't the issue here. It's the Waldman statements. And Waldmanian, I don't even know what that is.
Thank you.
It's not relevant to this case.
I don't even know what that is either. So good.
I think take that one down, please, Tom. Mr. Banya, what other work have you done in connection with forming your opinions about Mr. Schnell's testimony?
Again, the assignment was to determine if the Waldman statements were part of the tweet. So I continued to dig in, to the data. I believe the next step is, now that I've excluded, the 35% that was before the Waldman statements because they were irrelevant, I wanted to really analyze from the April 2020 forward to see if any of those tweets, contained the Waldman statements.
Did you prepare a demonstrative that reflects that analysis that you did?
Yes, I did.
Another demonstrative.
Yes, ma'am.
Love it. I was just thinking that
Any objections, sir?
No objection as a demonstrative.
Okay,
All
hold
right.
on, I'll wait.
We'll mark it for identification as plaintiffs 1295 as demonstrative and published to the jury.
So, Mr. Banya, did you consider the content of the statements made by Waldman as part of the work that you did?
Yes. Yeah, so here I reviewed the Waldman statements again. And what I wanted to do is I wanted to determine what, if any, tweets included the Waldman statements. So what I went back to the Waldman statements, and I came up with key terms and key themes for those Waldman statements, which are listed here. The Waldman statements were about abuse hoax, sexual violence hoax, and fake sexual violence. So what I did is we're now dealing with a 1.2 million tweets because, we're starting in April 2020 because that's when the Waldman statements started. And what I did is I searched the 1.2 million tweets, for these three phrases. And I determined that there were 751 tweets that included those key terms, which is 0.06% of the 1.2 million. And then as I was sifting and sorting and analyzing this data, I realized that a lot of these tweets had the exact same language. It was interesting to see it was the exact same tweet because I'm analyzing the language to see if it matches one of these three. I realized that a lot of these tweets were retweets, likes, or shares. So therefore I eliminated any of those, and it came down with 95 unique tweets. And then what I did from there is I analyzed those to determine if any of these terms were in there. And I identified 5 tweets that were related to the Waldman statements.
5.
Do any of the hashtags Mr. Schnell analyzed include the words from the Waldman statements?
No, they don't. And, because I am rebutting Ms. Arnold, her testimony yesterday, she was saying that the Waldman statements caused these hashtags. Then throughout her testimony, she walked that back and admitted,
No, none of these tweets have anything to do with the Waldman statements. They don't include the Waldman statements. You know, these hashtags are only hashtags that Schnell, in his opinion, felt that they were negative towards Ms. Heard.
Based on your expertise, what are your overall opinions about Mr. Schnell's testimony and the Twitter hashtag data?
You know, Mr. Schnell provided no evidence that any of the tweets were related to the Waldman statements. Mr. Schnell, there's no correlation there. He also provided no evidence that there's any causation that, you know, the Waldman statements caused any economic harm towards Ms. Heard.
Your Honor, I'm about to switch to a different topic. I don't know if you want to break now or push.
All right, it's going to be a little while, I assume?
A little bit more, yes.
Okay.
Yeah.
Let's go ahead and break for lunch, ladies and gentlemen, okay? Do not discuss the case and do not do any outside research, okay?
Wow. So, again, I can't stress this enough. The fact that they are ending on this note in their rebuttal witnesses is the correct way to end it. And when what I was just thinking about is different YouTube channels that are covering this case currently. So you have the channels that are lawyers that are covering this case and are giving the viewpoints from of the law and their understanding of the law and how it applies or doesn't apply to this case, which is extremely important because in order to understand the case, you have to understand a lot of these legal terms and really like the difference in the legal definition of maliciousness or with malice versus the like true Oxford English Dictionary definition of malice, right? Because it means something different. And what they contribute is extremely, extremely important. I've learned a lot from listening to their analysis. Conversely, you have channels like mine who are just regular people who have some knowledge of the law, but not a working knowledge. I don't have a education in law. I don't have a license to practice law. I'm not on the board. All that. Didn't take the bar, yada, yada, yada. And what I find is that what's interesting to me about all of this is the jury, though, is made up of people like me more than actual attorneys, right? Typically, that's what happens. It's a jury that's made up of regular, everyday people. And the reason that I am so appreciative of the way that that Johnny Depp's team has decided to present their rebuttal case is because, again, it goes back to what the heart of what this lawsuit is actually about. And for their team to call in witnesses that are not only quite capable in their fields of expertise, but the other part of that that's so very important, the element of being able to explain it to people who don't have any experience in their particular fields of expertise. It's one thing to have all the knowledge of a specific field. It's another thing to be able to take the knowledge that you have and explain it in a way that most people can understand. And I think that what we've seen throughout this trial is that when it comes to expert witnesses, Johnny Depp's team has been able to put on witnesses that are experts in their field and there is no question about that. But the other element is met, which is that they're able to take the knowledge that they have and break it down in a way that is easy for everyone to understand. And that is where Amber Heard's team is sorely lacking. Now, I don't know how much time Amber Heard's team has left on the clock, but if they hope to salvage her defamation countersuit, they need to get people on the stand who are able to explain things to the jury the way that the Depp experts have been able to. And that's where they are lacking. Again, this witness just exemplified exactly what I was saying earlier today and yesterday, which is that the Heard team has had difficulty, frankly, and actually, to really be more specific, they have failed to connect dots that must be connected in order for them to be successful in proving Amber Heard's defamation countersuit. And they have not been able thus far to do that. I would encourage them to work harder at doing that, because they, in my opinion, are losing this jury because they are of their fundamental inability to put on witnesses that can explain things to the jury in this way. I don't actually think that they will. I've learned a lot, to be quite honest with you, because it's very late in the game, and they would have to find these last two witnesses, well, three really specifically, have systematically and surgically dismantled every single argument or bit of testimony that their counterparts on the other side, on Amber Heard's side, made over the trial. And not only have they been able to do it systematically and surgically, they have also been able to convey in a much better way how they did it and why their data, their analysis is correct over the opinions rendered by her expert witnesses. And they don't have enough time. This is something that they should have been doing from the beginning. And it doesn't, I mean, even if they had 16 hours left, I don't think that they would be able to accomplish this. But I do, I'm curious to see what they do with their time. So I want to thank everyone for being here. I have so enjoyed it. This is where I leave you. I will be back tonight. I don't know if I'm going to go at 8 Eastern or 9 Eastern, or maybe somewhere in between, like 8:30. I'm not sure yet. I'm going to see what's left from today. I'm going to watch a little bit of it and then go from there. But I was wondering how you guys feel about having an open panel at the end of this week. And we can all, that way, you guys, I really want to hear what you guys think about all of this. And, I can't promise you that the internet is not a safe place. And I can't promise you that if you give your opinion that some place on the internet isn't going to find it and has some type of rebuttal. I couldn't possibly promise you that. But what I can promise you is that if you do come up on panel and you do discuss your opinions, I will treat you with respect, and so will the chat. And that's all that I can do. But I would really, really love to hear from you guys a lot. I will say this. Let me keep this up here. If there were a witness to cause Elaine to blow her top, I think it would be Kate Moss. Because the thing about Kate Moss is, yes, she is a supermodel, which let me just point this out. Kate Moss, for her to be a supermodel, it's one thing to be a print model, right? It's another thing to be a supermodel. Supermodel means you model. I know you guys know this in the fashion shows. You walk the runway, okay? Kate Moss is 5'7", and while that is on the the higher end, right, of the average, she's taller than the average woman. As far as supermodels go, she's really on the short side, and very, very rarely, like I'm talking once in a blue moon, do supermodels of her stature, height, make it actually become supermodels, right? And so she beat those odds. But more to the point, she does have experience with the media and taking and giving interviews and being asked difficult questions. And that is excellent experience. And I'm curious to see how that will translate in the courtroom, because it's obviously going to be one thing for her to be on direct. The direct is not the hard part. The hard part comes at cross. And so I'm very, 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 very curious how often I'm curious. I think Elaine is going to be the one that questions her, and I think Elaine is going to become frustrated with her. I didn't even realize you got her name wrong until you wrote this, because I read it Elaine because that's how I read her name, Elaine. And there's one other, and yes, she is drop dead gorgeous. I used to be obsessed with Kate Moss. I had a whole album full of her pictures because I just thought she was so gorgeous. And it's very, very rare. And yes, also, see, this is another thing. I think what Amber Heard's team failed to, I think they underestimated the human component to the jury. And the thing is, I think what they thought was going to happen with the testimony of substance abuse and prescription drug abuse is that the jury would take the position of, these people have everything and this is what they're doing, right? But I think that they underestimated the humanity in a juror. And the truth is, that may have been an attitude years ago, probably towards the probably towards the beginning of 2000, even up until 2010. So I'm talking about a decade ago at the latest, right? That would have been a juror's attitude. That would be kind of a safe bet. But the truth is that as we evolve as a society and we begin talking about things openly that we didn't talk about before, like substance abuse issues, people's opinions change. And especially when it comes to prescription medication, because you're getting prescription medication from a trusted source, your doctor. And what they don't tell you when it comes to taking pain medication for an extended period of time for like chronic pain, right? Taking an opioid for long periods of time because of chronic pain. Chronic pain works differently. It affects you physically differently and it affects you mentally differently. I've had both. I've had chronic back pain, and then I've had acute pain from having 4 C-sections, and it is different in every way. And I think that even though you know that opioids because of their compound, their chemical compound, they are habit forming. Your body can become addicted to them. It's interesting that you don't really realize it until it has you. And I think that that is something that most jurors can relate to. And I really think that I think that Amber Heard's team underestimated the humanity in the jurors. And I think it was a huge mistake on their part, and an even bigger mistake on whoever it was that advised Amber Heard to distance herself from the drug use, and whether that be the illicit substances or the prescription medications, whatever, she's distanced herself from it. What, acknowledging that she has tried it, but she has or has done it, but she has completely downplayed it and made, um, you know, she's a dabbler and Johnny Depp is a doer. You know what I mean? And that was a mistake, in my opinion. So, anyway, I just want to thank everybody for being here. You guys are so great. I really appreciate the support. I've so enjoyed our chats. I can't wait to see how this turns out. And also for our next case, I'm scoping out what's coming up as far as trials go, so we can have more of this, because I really enjoy this. But I'm going to end it for now, and I will see you guys sometime tonight between 8 and 9. So make sure you guys have subscribed. You turn your notifications to all so you get notified. I usually schedule the stream 2 hours prior. So there you go. All right. You guys have a great rest of your day, and I will talk to y'all tonight. Bye.